Hey, Will, it's Andrew.
Hey, Andrew.
Hey, just want to make sure my audio is working.
Sound good.
Thanks.
Hey, Will, it's Janet.
Hi, Janet. How are you?
Good, how are you?
Doing well.
All right.
Hey, Will, can you hear me? It's Charlie.
Hey, Charlie.
Great.
Hi, Will. Just doing a quick sound check.
Could we do a sound check, everybody, to see if everybody can hear?
I can hear you, Will. Can you hear me?
Yep, can hear you fine.
Hey, Will, this is Seema.
Hey, Seema.
This is Rob, Will.
Hey, Rob. Hey, David.
Hey guys, good afternoon.
Nice haircut.
It's the COVID cut.
Throwing the beard back too.
I'm getting the beard back. I took this off. When you have a 15-year-old and he dares you to do it, you do it.
You guys are getting bored.
Yep.
I've heard everyone's getting home haircuts and dental treatments and all that stuff.
That could be dangerous.
Yeah.
Hey,
Who's
Will,
getting
it's
a
Andrew.
home? Who's getting a home dental treatment? And what is
I'm
that?
kidding. It's like
Okay.
home, everything's being done at home. Manicure, haircuts, all that stuff.
I don't know if we're gonna start drilling someone's teeth. I'm not signing up for that.
Yeah, I'm busy that night too.
Everybody, can you hear me?
Yep.
Okay. We're not going to have the chat feature on?
No, ma'am, we don't have the chat feature on. Vicky, if you don't mind, we'll turn your video off and we'll just have council up at the beginning. I'm going to turn my video off now too.
Vice Mayor McKenzie's going to call the meeting to order and everything, right?
Yes, ma'am. We're only missing Councilwoman Parker at this point.
So I think since it is 5:32, we'll go ahead and call the meeting to order. Start with Pledge of Allegiance given by Councilmember Roberto.
Thank you, Vice Mayor. Everyone please stand and render the salute. I pledge allegiance to the flag
flag
of the United States of America
America,
and to the
and to the
republic
republic
for which it stands, one
one
nation,
nation,
under
under
God,
God,
indivisible,
indivisible,
liberty and
liberty,
justice
justice
for
for
all.
all.
Wow. Thank you. Mr. Johnson, if you'll do roll call, please.
Councilwoman Fugit. Vice Mayor McKenzie,
Here.
Councilwoman Parker, Councilwoman Ryder, Councilwoman Ryder, can't hear you.
How about now?
We can
Can
hear
you
you.
hear me?
Yes, ma'am.
All right.
Councilman Roberto,
Here,
Councilwoman Singh,
Here.
Councilman Smith,
Here,
Councilwoman Testerman,
Here.
Councilman Thomas,
Here.
all present but one, Vice Mayor.
All right, thank you. So at this time, we'll go into presentation. Agenda item A, would you like to read the caption, which is, well, I'll read it, an ordinance to amend Chapter 2, Articles 2 and 3 of the Knoxville City Code relating to the organization of the executive branch and the city's personnel system to reestablish a personnel department to be known as the Department of Human Services and for related purposes. This was requested by Mayor Kincannon. Council members, we all have the ordinance. We should have received that prior to the workshop. At this time, I'd like to ask Mayor Kincannon if she'll just give us some background, if you will, please.
Thank you, Vice Mayor McKenzie. Can everyone hear me okay? Okay, it's good to see you. Thank you for taking the time to dig into this topic. I know that you all care very deeply about our employees, and so do I. Our employees are our most important resource as we serve the city of Knoxville. And I know that we all want to make sure that we're investing in our workforce and in our people. This, as you know, has been a topic of conversation across several administrations. It's been discussed, this change has been discussed with Mayor Haslam, and Mayor Rogero began the effort in a more concerted way a couple years ago, and even went as far as budgeting a couple positions for it in the FY20 budget. And I have taken a look at the work that the previous administrations have done and feel responsible to continue the conversation and to help ensure that the city remains a model employer that's practicing 21st century best practices. I'm going to give a short overview. Well, I don't know how short, but thank you for your patience. And we can take a few questions during this, but as you see in the agenda, there's someone from the Civil Service Merit Board who's going to discuss it. I guess that will be Vicky. And then the presentation of the ordinance, like the nitty gritty details, that's going to be presented by George Shields and Charles Swanson. So please know that those nitty gritty questions, I would ask you to save those for that portion of the agenda. One of the most important things I want you to get from, hi, Councilwoman Parker, welcome. I'm giving a presentation, just a little background before we get into the other parts of the agenda. So one of the most important things I want you all to take away from my discussion is that I'm fully committed to and support the civil service merit system. And I want that to be true, not just for my administration, but for whoever may be mayor in the future and whoever may be on council in the future. Merit-based examination, certification, appointment, and promotion, that is super important. Prohibiting discrimination, of course, is vital. And disciplining people only for cause, and ensuring that all appeals and grievances are heard and resolved through fair proceedings. I'm fully committed to those. Those are in place now, and I want to make sure that those protections are sustained and protected and continue in every possible way. Reestablishing the Human Resources Department is not going to impair or diminish the rights, benefits, or privileges of civil service employees established in the city charter. And we'll get into the specific language about that, later on when George and Charles shared, go into the legal aspects. And I know we have, what, 3 lawyers on council and other people who are really good at delving into these things. So I'm glad George and Charles are here to help with that level of detail. I believe firmly that restoring an HR department will strengthen the civil service merit system by enabling the merit board to use its resources to focus exclusively on its charter-based function, ensuring that personnel actions continue to be made on the basis of merit. I feel this is so important that the integrity of that crucial civil service function is so important that right now there's an inherent conflict of interest present when the same entity that's responsible for providing impartial review of personnel related decisions is the same one making those decisions in the first place. And so that's what we have right now, and it results in employees questioning the integrity of the civil service system. One of the important benefits of establishing an HR office is that it resolves this conflict of interest and helps the city, the civil service, helps us monitor the city's personnel system more effectively. I mentioned this also, I was going to share this with you by email, but I just didn't get a chance to. I can send it as a follow-up later tonight or tomorrow. I asked the Municipal Technical Advisory Service, MTAS, to tell me what other cities and towns across the state do. And they surveyed cities and towns across Tennessee, and the vast majority, every single one that they surveyed, and I think they got responses from about 20, have an HR department except Knoxville. And 2 cities, Nashville and Memphis, have an HR and a civil service department. We're the only one that only has civil service. And I recognize that our civil service department currently performs some HR functions, but we're the only one with this unusual arrangement where civil service merit board is also performing these, HR functions. It's something that I haven't seen in any other place. And the MTAS, I appreciate their help in doing that survey for us. So I use the term reestablish in HR because we'd actually be returning to a structure that existed in the 1980s. The city had a personnel department that performed all the functions that are now being proposed in the HR department. It was responsible for the administration of all personnel things, and the merit board focused on the charter function, ensuring that personnel actions were made on the basis of merit. This change happened. It was actually Janet's father, Kyle Testerman, was mayor at the time, and they were undergoing some budget constraints. And Mintha Roach was the head of civil service at that time, and he asked her if she would be willing and able to merge those roles for the sake of a budget, and she agreed to do that. And it has been in that structure ever since. There was no charter change at that time, and I'm not proposing a charter change to undo that and restore an HR function either. So as much as it is so important to protect employees from discrimination, employees need a lot more than just protection from discrimination. They also need and deserve training, career paths, modern recruitment and retention strategies, and support to deal with all kinds of workplace challenges, including the ones we're facing right now with COVID-19. So a few of the things that I would anticipate an HR department overseeing are marketing and talent acquisition. A lot has changed since the 1980s, especially the labor market. You are all really familiar with the challenges we face in all departments, but in particular our law enforcement in trying to recruit people. An HR department would be able to go on beyond the civil service charter has a recruitment function where you post vacancies and accept applications, and they would still be responsible for that. But there's a lot more to recruitment and retention than just posting an opening to the website. And that's one of the things I think HR can do. And I'm also looking forward to the Ackerman report that we asked a marketing entity to do to examine how we do KPD enforcement, recruitment. That's going to be coming out next week. And I think that some of their recommendations will be very well suited for something like an HR department to implement. Another function I would hope that an HR department would take over is classification, compensation, and performance pay. This would enhance our recruitment intention and really allow us, and this is something I think that is probably most important to employees, is the compensation and classification. These are functions that were formerly performed by the personnel department, and we need to be able to compensate our employees fairly and in a way that's consistent with the market, and to be able to devise surveys and so forth that are consistent with modern labor market practices. That we are working hard to attract people to work for Knoxville, and it's people have a lot of other options. So we need to ensure that our compensation and performance pay policies, are up to speed with the modern labor market. And another really important function that we're really lucky to have some great managers in the city of Knoxville, but it sort of happens in an ad hoc manner. So I would love for an HR department to more proactively help managers and supervisors develop a positive workplace culture and focus on developing and supporting that environment so people know how to appropriately develop the people that they oversee and do progressive discipline as needed, and just be able to train our managers to be effective as possible. I'd also want an HR department to work on our onboarding and orientation functions. We have some capacity in that area right now, but I think it could be better, and I think that would help cultivate long, successful, and productive careers that better serve our residents. So that's a little bit of an overview of why I'm bringing this to the table right now, and that it's not a new thing. It's been something that's been in the works for several administrations, and Mayor O'Hara, worked really hard on it for the last couple of years, but then just got busy and ran out of time with her administration. So I'm just taking it from, I guess, hopefully from third plate to home base, and in collaboration with you all, of course, and with our employees. So now I guess, Vice Mayor McKenzie, I could take some questions, or we can segue into Vicki Hatfield. She's the Executive Secretary of the Civil Service Merit Board, and I think she's going to be presenting the next agenda item. But I can take a few questions now, or we can wait till later, whatever you all want.
Do any council members have any specific questions for the mayor at this juncture based on the information that she just shared? Okay. If not, we will table any questions until the end. So we actually asked Vicki Hatfield to dial into the meeting and participate to answer questions of council members toward the end. We actually had requested a member of the Civil Service Merit Board to be on the call today to share their position or their feedback regarding this ordinance. They did have a call yesterday, and they elected a new chair of their board, which is Jamie Ballinger. And congratulations to Ms. Ballinger. Yesterday, the board tabled this particular topic because they did need to do some additional due diligence and had a lot of additional information that came into them that they needed to review. They are going to take this up at their May 2nd meeting. So what the council will do is we will ask them to log into our council meeting when this item will be on the agenda to share with us their position and their comments and feedback. Okay. So at this time we'll go on, we'll move to the presentation of the ordinance at this time.
Well, I think I was going to be first on that. This is Charles. I don't know if anybody recognizes my voice or not, but this is Charles, and I would just the ordinance. Know that the things that you all have heard some questions about and concerns about has to do with whether or not through adoption of this ordinance, we are in any way going to impair the civil service protections afforded to employees, which currently exist under the charter of the city of Knoxville. And I want you to understand that that is not what is happening with regard to this ordinance. This is an ordinance. This is not a charter change. And that's very important because the charter protections that are afforded to city employees are protections that are afforded in the city charter. And an ordinance couldn't, even if it wanted to, an ordinance couldn't trump those charter provisions. It's just like it works in the state government, where a state statute cannot trump the state constitution, neither can a federal statute trump the provisions of the United States Constitution. For all practical purposes, for the city of Knoxville, our charter is our constitution, and we cannot do anything by ordinance that would impair the provisions of that charter. So I want you just to be aware of that fact up front. And it was never the intention of this mayor or any other mayor that I've worked with regard to this subject, to try to impair any of the protections afforded to employees with regard to merit-based hiring, merit-based promotions, discipline being administered only with just cause. All of those things are the core functions of the Civil Service Merit Board. They will continue to be the core functions of the Civil Service Merit Board, and they will be strictly adhered to as the charter requires that they be. And I want you to know that when you look at this ordinance, and George Shields is going to go through this ordinance in great detail for you in just a minute, but as you go through the ordinance, there are a couple of things I want you to note particularly. One, which I don't think George will note for you, is in the 12th whereas clause in this ordinance, you will find the words, "The mayor's recommended reorganization does not in any way diminish or impair the civil service merit system rights and privileges afforded by the city charter to city employees in the classified service." That is right there in the ordinance. It says so in the ordinance. We put it in the ordinance because we want any court who interprets for any reason to understand that it was never our intent. I had to okay my video, which is really a bad idea on anybody's part. But at any rate, what I was saying is it was never our intent to impair the charter here. And that's why we said so particularly. And we put those words in there so a court, when it goes back and somebody wants to challenge something based on their charter protections, we want the court to know that we never intended to impair their charter protections with this ordinance in any way. It says so right there in the ordinance. After talking at some length with Chief Thomas, who's been talking to some of her folks, she felt like it would be a good idea to put some additional language in there with regard to assuring the employees that this is not an effort to impair their charter protections that are in civil service. And so we have made a change in section 6 of the ordinance, and George will go over that with you, but based on the recommendation of Chief Thomas, we have made the change to start. That's where it talks about what the functions of the HR department will be, what the responsibilities of the HR director and the functions of the HR department will be. And the first thing that we're going to say there is, subject to the civil service protection afforded to employees under the city charter, the Department of Human Resources shall operate, and then it will list the various things that the Department of Human Resources shall do. But we're going to say right up front that this is not in any way intended to impair those civil service protections. It is subject to the civil service protections afforded to the employees under the charter. So I just wanted to get that out front, let you all know that that's what our intent was in this, and that's how we have crafted this ordinance in a way that protects the civil service protections of our employees. Now I'm going to turn it over to George Shields, who knows all the details of this ordinance and knows the history of this ordinance. And he's going to go through the operative sections of the ordinance with you in a sort of a line by line basis to help you understand. And you might want to, if you have questions as he goes along in particular sections, if you have questions with regard to the section that he's on, you might go ahead and address those questions as he goes through those sections, because that might be more helpful to you. George?
Thank you, Charles. I appreciate it. And thank you to the members of the council for providing the opportunity for me to go over this ordinance with you. I've provided a PDF version of the ordinance to Will, and I think Will will be able to share that on the screen. So no matter what your situation is right now, we'll all be literally reading off the same page together. And then Will, if you can start us off on section 1. Okay, great. Is everybody able to see sections 1 and 2 there? Okay. And so like Charles mentioned, what I'm going to be doing is going section by section with you. And so section 1 is the start of that process. Before I get into that, though, I want to touch on some of the background elements that others have already mentioned. First is that this is an ordinance to reestablish the former personnel department and then rename it the Department of Human Resources, and then empower it to administer the city's personnel system. So at the broadest possible level, that's what this ordinance is doing. At the same time, though, as the mayor and as Charles have mentioned, the ordinance preserves all of the civil service protections guaranteed to city employees under the city charter. And this is both by design, because this administration does not want to alter those protections, and also by law, because as Charles said, no ordinance by itself could amend the city charter. And moreover, no charter amendment is necessary to accomplish the objectives of this ordinance, because when our current charter, the one we have today, was drafted and approved by referendum in 1980, the city had a personnel department. In fact, the city had a personnel department under various names, accountable to the mayor for more than a decade by that point. Our charter was therefore written and approved with the understanding that both civil service and a personnel department already existed. And after our charter took effect, both entities continued to coexist, again, under the very same charter we have today, for another 6 years until, as the mayor mentioned, for budgetary reasons, the personnel department was eliminated and its functions were transferred to the Civil Service Merit Board. So this ordinance ultimately is restoring the arrangements that the charter had in mind at the time it was created. And it also adds some additional functions to the HR department that aren't currently being performed on a citywide basis by any department. And one of those examples is employment marketing and outreach and talent acquisition. We'll talk about that a little further in. So with that background, section 1 is repealing the old ordinance from 1986 that eliminated the personnel department. And we don't often include repeal language. Sometimes we just move on to making the changes without going back and finding the source for the change that we're undoing. But we thought it was important here to put that right up front to illustrate again that we're trying to maintain consistency with what the charter itself had in mind. This isn't something new. This is returning to a model that we used to use. Section 2 does 2 things. It first corrects, frankly, a past drafting oversight that resulted in the Department of Employee Benefits and Risk Management being omitted from the list of the city's departments. And because we're having to make some changes to the Employee Benefits Department's functions, this was the appropriate time to make that housekeeping fix. And then second, you'll see it also adds the Department of Human Resources to that same list. So these 2 will be added onto a long list of existing departments, sort of taking their place alongside peer departments in this section of the code. And then Will, if you're ready, I'll be glad to move on to section 3. So section 3 is confirming something that is already true. The Director of Law is already responsible for advising the mayor on official acts and on other matters of legal consequence. That existing responsibility already includes advising the mayor on the city's administrative rules, which is one of the 2 bodies of rules that govern most of the day-to-day aspects of employment at the city. And so this section is simply confirming that existing reality in the code for the avoidance of any doubt. And because we're going to be talking about the administrative rules later on in the ordinance, this was the appropriate time to sort of recognize that reality. Section 4 is both deleting a function and adding a function to the list of those functions that are performed by the Employee Benefits Department. It first deletes responsibility for developing employees through training. In practice, what Employee Benefits does in the training space right now is focused on its risk functions. It's about occupational safety and health and related risk prevention type training programs. It's not holistic training in the way that you might think of a corporate HR department offering training on a variety of subjects to a variety of employees. And so in some respects, deleting that is just recognizing the reality that department is not providing citywide training, and we intend the HR department to provide that citywide training. So we first have to delete it from the employee benefits section. But then we're also adding to the employee benefits section the responsibility for administering both paid and unpaid forms of leave. Currently, leave is divided between employee benefits, which handles leave pursuant to the Family and Medical Leave Act, and then also civil service, which handles most other forms of leave. This ordinance would consolidate all those types of leave under the benefits department, which happens to also be the heading that our city code already uses to categorize leave. It's categorized as a benefit. And so that covers section 3 and 4. I'll be glad to move on to 5 and 6. 5 and 6 is a little bit of housekeeping as well, or 5 particularly is. 6 is more than housekeeping. 5 is deleting the current requirement that the employee benefits director reports to the finance director. It hasn't been the case that that has been the reporting arrangement for some time. And so this change is, again, just confirming our existing practice. Section 6, though, does more than that. We're going to spend several slides on Section 6. Section 6 starts to reestablish the personnel department under the name the Department of Human Resources, and the next several slides will lay out the details of the department's duties and functions. So first, you may have seen in the code where departments are created, there's usually a description of the duties of the director, and then usually a description of the functions of the department. So this is the first half of that. This would establish the duties of the director. And so it would say first that the HR director is the city's chief human resources officer. You'll see that there in the text. The ordinance would direct that except in cases where some personnel responsibility is assigned elsewhere, the responsibility for personnel matters would rest with this director. This language is patterned off of similar language used to describe the finance director's role. And similar with finance, where there are financial functions happening in other places other than just in the finance department, but ultimately the responsibility rests with finance. This language also recognizes that there are existing personnel functions happening in other parts of the city. For example, obviously the Civil Service Merit Board has a place in the personnel system, and where it has express roles to play, those roles are preserved. There's no change. But also directors have existing roles other than the HR director. Each director is a hiring authority for their department, and each director is a disciplinary authority when disciplinary issues arise. And so that language is designed to preserve their existing responsibilities as well. It's in those gaps where there aren't some existing authority that the HR director fills the gap. And so, and finally, as Charles mentioned, as the first sentence states right off the bat, all of this is subject to the existing civil service protection afforded to employees under the city charter. Will, okay. Great. So now we move into the department's functions list, and this will take a few slides. They're numbered. And so the first two, first is enhancing the relationship between the administration and employees. This is something that HR would have in common with employee benefits. If you were to look up the corresponding section that describes employee benefits, they're also tasking with enhancing that relationship. It makes sense that HR would have a role in that as well. Next is administering comprehensive, diverse, and inclusive employment marketing, outreach, and talent acquisition programs. This is already happening in some departments, but it's only happening on a department by department basis. For example, you've already heard and you're already aware that KPD engages in some in-house marketing on its own, and public service and fleet services do some of that as well. This ordinance builds on that existing reality by making it a citywide priority and tasking HR with delivering on it. At the same time, civil service will continue to perform its charter-based recruitment function, namely posting vacancies and accepting applications, as well as its examination and certification functions. In other words, this marketing function goes beyond what civil service does, but it doesn't take away from what civil service does. Okay, moving on to number 3, continuing the list of HR department functions. Section 6, part 3 here, next assigns the HR department the responsibility for a class of functions that have been referred to as post-selection, but still pre-employment processes. And these are things like background checks and medical and psychological examinations and pre-employment drug and alcohol testing. While these are currently coordinated by civil service, these functions are closely aligned with the risk management department, and the standards are typically set by risk management. The pre-employment health-related functions in particular were formerly performed by the Personnel Department when the city last had both that department and civil service under the current charter. And this ordinance restores those functions back to the HR department. Section 6 also tasks HR with assisting the city's hiring authorities with interviewing and selecting applicants for employment and candidates for promotion. But note that this is an assist function, so the degree to which one department needs or wants that assistance may vary. To the extent that directors feel that they would benefit from having that assistance, the HR department will provide it. But again, this does not alter civil services charter role in recruitment, examination, and certification. It's simply providing additional HR expertise to help directors in making the decisions that they have to make using the authorities that are already provided to them. And next, Section 6 tasks HR with enhancing employee growth and retention through administering the city's orientation and onboarding functions, citywide training programs and organizational development initiatives, performance management, the performance pay program, and leadership development and succession planning training for supervisors. And then moving on now, we're still in Section 6, numbered item 6. Section 6 next assigns to the HR department the responsibility for administering the classification and compensation plans. Both of these plans were administered by the Personnel Department when the city last had both that department and the Civil Service Merit Board under the current charter. Several later sections will address classification in more detail, as well as some that will address compensation. In terms of compensation, currently compensation recommendations are made by civil service to the mayor, but the mayor decides whether to accept or modify or reject those recommendations as part of the budget process, which of course the council ultimately acts on. Currently, however, the mayor does not have any staff accountable to her to assist her in this role. This ordinance, by returning compensation to the HR department, solves that problem. In addition, this ordinance would jointly task HR and civil service with maintaining the city's personnel records. It would also task HR with responding to public records requests involving those personnel records. HR would also provide advice to directors as needed with employee disciplinary matters, and HR would take over administering the city's unemployment compensation program. Moving on to Section 7 and 8. Section 7 is another of those housekeeping fixes. The charter treats classification and compensation as separate plans plural with an S, but sometimes the code currently references them as though they were a single plan, singular. And so Section 7 is the first of a few housekeeping fixes that aligns the code with what the charter has been saying the whole time to fix that issue. So we've added an S there onto the end of plans. Section 8 is another housekeeping fix. It deletes an old transitional provision that was used when the city first transitioned to having a classification plan. So again, it's just a little pruning of the city code there. Section 9 is another of those housekeeping fixes. This section of the code is currently titled Maintenance of Plan, singular, but because it addresses both the compensation and classification plans, we've added the S on to make sure that it's clear that we're talking about those two plans, and we've added the word administration to be consistent with the terms we're using to describe the maintenance of that plan. It's an administering function. And then Section 10. Section 10 addresses the classification plan. The code currently assigns responsibility for maintaining the classification plan to the Civil Service Merit Board through its executive secretary, and tasks the executive secretary to periodically review the classification plan and recommend amendments to the mayor. Section 10 assigns those responsibilities to the HR director, which is consistent with the arrangement that was in effect when the city last had both the Personnel Department and the Civil Service Merit Board under our current charter. Section 10 then goes on to add additional language that confirms that the Civil Service Merit Board may monitor the classification plan and the classification and reclassification of employees in accordance with the provisions of the city charter. This additional language is almost word for word the same as the language that was in the code when the city last had both the Personnel Department and the Civil Service Merit Board under our current charter. Moving on to sections 11 and 12, section 11 deletes a section of the code that tasks the Civil Service Merit Board with making rules related to classification and compensation. The Civil Service Merit Board gained that authority only after the Personnel Department was eliminated in 1986. The charter itself does not task the board with making these rules. As part of returning responsibility for classification and compensation to the HR department, this section would relocate those rules to the administrative rules.
Hey, George,
Yes, sir.
it's Andrew Roberto. I had a question about section 11, if we could stay there for a second.
Sure.
The section that's being deleted here and is about rule changes, and I know that there's been several questions about and concerns about rule changes. Presently, with regard to this types of rules that this section is particularly referencing, those rule changes will be held in a publicly held and noticed meeting. Is that correct?
That's right. For the merit board to make rules on any subject, it has to do it through notice in a meeting.
Okay. And then I know in this particular ordinance, we're not addressing that specific rule. So as is, there wouldn't be a requirement to have a publicly noticed meeting or a public meeting about these proposed rule changes.
That's right. The ordinance doesn't get into that level of detail here. It's only addressing who is making the rules, but not necessarily the mechanics of how the rules are being made. The board makes its rules through that process because of the type of body it is. The administrative rules are made ultimately under the authority of the mayor through a staff process, where the relevant employees in the city that have expertise on a particular matter, they work together to recommend a change that's vetted through the law department, presented to the mayor, and ultimately it's the mayor's to approve. So the mechanics of how the rules get made are different in those two instances because the nature of the final approval is different. One is a body, a board, and the other is an individual elected official. That's not to say, though, that the city would not be intending to make sure there was feedback on those rules. And that's something we're actively looking at right now. It just means that the mechanics of how that feedback would be received may be a little bit different because of the nature of how the rule is made.
Well, and this may be more of a policy thought, but one way to address that would be to just have a public notice of any proposed rule changes and allow maybe like a 10-day comment period before the rule change would go into effect. I think that something added there, and I understand exactly what you're saying, hey, this is the framework, and then when you get into the rules, we deal with, some of the specifics, but addressing that particular concern with some minor changes here, I think might alleviate some of those concerns.
Yeah, I appreciate that point. I'll take that down and we'll look into that a little further. Like I mentioned, it's already something we're looking into. We want to make sure that employees know that there's a desire for feedback on these issues. And so I appreciate the suggestion about how we might do that. If there's no other questions on section 11, I'll move on to section 12. Okay, section 12 modifies the provision of the code that describes class specifications, which are like job descriptions. The code currently says that the executive secretary of the Civil Service Merit Board, but not the board itself, approves and maintains this master set of class specifications. This section would transfer that responsibility back to the HR director, which is consistent with the arrangement that was in effect when the city last had both the personnel department and the merit board under our current charter. But again, section 12 adds additional language that confirms that while class specifications will be approved and maintained through that executive structure, the Civil Service Merit Board may monitor class specifications in accordance with the provisions of the city charter. This additional language is almost word for word the same as the language that was in the code when we last had both that personnel department and the Civil Service Merit Board under our current charter. Then moving on to section 13. Section 13 addresses the procedure that applies when an employee requests a review of their own classification. Currently, employees request reclassification through their director, who can recommend the reclassification or not, to the executive secretary of the Civil Service Merit Board, and the executive secretary makes the decision ultimately on that. Section 13 restores almost the same language that was previously in the code when the city last had both a personnel department and a Civil Service Merit Board under our current charter. At that time, the employee's request would route through their director to the personnel department, and the personnel director would make the decision on the request. But an employee at that time could appeal that decision of the personnel director to the mayor. Section 13 would restore the same arrangement, except Section 13 does not permit employees to appeal to the mayor. What does not change, however, is the existing right of an employee to take a reclassification complaint to the Civil Service Merit Board, to ask that the board investigate whether merit system principles were violated, and if the board determines that those principles were violated, to have the board order a remedy. So to be perfectly clear, the right to appeal language that you see at the end of the section is speaking in terms of being able to appeal beyond the HR director to, for example, a deputy mayor or a mayor. This stops the HR decision at the HR professional. It doesn't allow that appeal to go beyond someone who's knowledgeable in HR. But again, the charter already says that if an employee has a complaint related to a violation of merit system principles, the employee can always bring that complaint to the Civil Service Merit Board. The appeal language is not speaking to that arrangement at all. It's speaking to whether you can bypass the HR director and take your complaint on to the mayor. And so I hope that helps to clarify. I know that's been a topic of discussion. And as we've mentioned already, and as you'll see in other places, we frequently state that the Civil Service Merit Board may monitor the classification and reclassification of employees consistent with the charter. This section doesn't say that because the old section in the 80s didn't say that, but the impact was the same. The Merit Board could then monitor those classification and reclassification matters, and under the ordinance, they would also be able to monitor those issues.
George, it's Andrew Roberto again. I've got a question on section 13. I think you identified this, that last line in this particular section about is final without the right to appeal. I think that has certainly generated some discussion that I've heard. That might be a good place, and I think you identified that, but it might be a good place for looking at some amendment there to be, I totally understand what you're saying is that, or the intent of saying here is, we're not having folks go directly to the mayor or deputy mayors to override something that's going on. But there may be some work needed on that language, because certainly when you read it, it doesn't necessarily convey the message that I think you're trying to. And then, specifically when you're thinking about the current rules that the Civil Service Merit Board has, I think there's a rule currently in place about reclassifications being posted for at least 10 days prior to reclassification. Is that something that would be addressed in the rules we talked about earlier that would need to be adopted, or is that something that we would need to spell out here in this framework?
To your first point, I appreciate your comment there about clarifying what the intent of the appeal language is. That's something that we've mirrored, like I said, almost word for word what was there previously, but that doesn't mean we necessarily have to stay with that if there's a need for clarity. So as far as the where to address that second level of procedure when it comes to these reclassification requests, the answer is traditionally, up until this point, they have not been addressed in the code. That has been left to the underlying rules to spell out exactly what the mechanics would be beyond what you see in the code here. So whether there would be a 10-day comment period is currently something that's only provided for in the Merit Board's rules. And so I would anticipate that if the rules were under the administrative rules in the future, the mechanics of that process would also be embodied there in that body of rules as well, if that answers your question.
I think it does, and I think that's another place to look at for potential amendment, because I certainly, what you're hearing is a lot of concern about reclassification, and if that was addressed maybe here, or if the rules that were going to be initially put together were published at the same time, I think that might alleviate some of those concerns.
Okay, I appreciate that. I'm taking that note down.
Mr. Shields, can You hear me? This is Lauren Ryder.
Yes, yes, ma'am.
I would just say I echo some concerns about that section 2452 in section 13. That is different than what was discussed at the Civil Service Merit Board yesterday. Is that correct or no? I feel like there was
Go ahead.
so this version that we're looking at, what's the draft date on this version that we're going through?
This version was adjusted today, but not in this section. The change today was to add the language that Charles referenced, that Chief Thomas had, and that was earlier. There hasn't been a change here.
Okay, so this is exactly what was discussed yesterday at Civil Service Merit Board.
That's right. This is something I tried to clarify yesterday on this same point. That's right.
Okay, well then I will echo Councilman Roberto from yesterday's discussion at Civil Service Merit Board meeting, as well as night. I don't think it's conveying what you mean for it to convey, and it's causing a bit of confusion and concern. So,
thank you.
Vice Mayor McKenzie, could I speak? I don't know how. I just want to say I'm reading and hearing you, and I have the same concern, and I think this is why we have the workshop, is to find these areas of concern, and we'll find a way to fix that. In particular, make the language so it reflects what we actually want to, how we want employees to have the power to appeal things, and where that would happen and that sort of thing. So we're taking note, I'm taking note, and we'll fix it.
thank you.
Okay, I'm ready to move on to 14 unless anyone else has questions on 13. Okay, hearing none. For section 14, this is another housekeeping fix to ensure that, consistent with the charter, we refer to the classification and compensation plans in the plural rather than the singular to make sure that we're technically consistent throughout. And then sections 15 and 16 are making compensation related changes consistent with restoring that function to the HR department. Section 15 transfers the responsibility for making performance pay rules to the administrative rules rather than in the merit board's rules. And section 16 tasks HR with conducting compensation surveys and submitting compensation recommendations to the mayor. These functions are currently performed by civil service, but they were previously performed by personnel when the city last had both the personnel department and the Civil Service Merit Board under our current charter. Will, if you can go to the next slide for me. Thank you. Section 17 makes the same changes we've already discussed related to the administration and maintenance of the classification and compensation plans, but it makes those changes applicable to the fire department. What we've been talking about up until this point are mostly sections that address the general government classification and compensation. The code has sort of trifurcated those things over the years to where there's distinct sections for general government, for fire, and then for police. And so the substance of the change is the same. It just typically has to be made, 3 times to cover all of that. So this is doing some of the same work we've already talked about, but in the fire department section. And like I mentioned, section 18 is doing the same thing regarding performance pay. Then section 19 makes HR responsible for conducting compensation surveys and submitting compensation recommendations to the mayor, also applicable to the fire department, the same ways we previously discussed. Section 20 makes the same changes we've already discussed related to the administration and maintenance of the classification and compensation plans, but now applicable to the police department as well. So you're seeing sort of the third version of those changes to make sure that we're covering everyone. Section 21 makes language adjustments to this section regarding the police department so that it matches a previous section in the fire department. There's some inconsistency there, but the intent is the same. And so this was another housekeeping opportunity to make sure that like looks like like. And then section 22 makes the same changes we've already talked about concerning performance pay, but here it's applicable to the police department. And then section 23 makes HR responsible for conducting compensation surveys for the police department, the same as we previously talked about for general government and fire. Section 24 makes changes to a provision related to annual leave and comp time. Currently, the rules and regulations related to annual leave and comp time are made by the executive secretary of the Civil Service Merit Board, but with subsequent approval by the mayor. Section 24 would remove the executive secretary's role as part of transferring the responsibility for paid leave to the Department of Employee Benefits and Risk Management. So it's consistent with what we've talked about earlier. It just has to be done a little later in the code. Then section 25 repeats what is already true in the charter. Charles mentioned this already. It's also set out in a whereas clause before we get into the operative language, but it's also here in the operative language. It's very clear that nothing in this ordinance shall impair or diminish the rights, benefits, and privileges of city employees in the classified service to examination, appointment, promotion, discipline, and retention, except in accordance with the provisions of the city charter. So like Charles mentioned, we wanted that to be a clear interpretive rule in case a court was ever called upon to construe this, so that it was clear what the city's intent was with it. And then section 26 is intended to ensure that any existing inconsistencies in rules don't override this ordinance. Instead, the ordinance should control. And this reflects that there would necessarily be some changes in rules in order to implement what the ordinance is talking about. But we would not want a situation to arise where before all of those changes could be made, some personnel matter arose and there was confusion about whether a rule or the ordinance was supposed to decide the issue. And so this is another interpretive guide that says, to the extent that there are any inconsistencies between those two bodies of rules, the ordinance is what controls, not the inconsistent rule. And then section 27 is designed to preserve the status quo other than what the ordinance requires. So it says that other than is set forth in the ordinance, nothing in the ordinance should be construed to authorize changes to rules either made by the mayor or the merit board, or to authorize either of them to make any rule that's currently provided for in the other's rule. In other words, except to the extent those changes have to be made by this ordinance, everything else should stay the same. Section 28 is just a little bit of lawyering there. It's a savings clause. You see those frequently. It's designed to make sure that if some part of the ordinance was held invalid by a court, the remaining sections that are not invalid would continue to apply. And then section 29 is the usual statement about when it would take effect. And so with that, I appreciate you letting me go through it in that level of detail, and I'll be happy to take questions.
Does anyone have any questions of Vice Mayor McKenzie?
Okay, I think I saw a couple of hands go up. We'll go to Councilmember Smith first.
Mr. Shields, I had a question about section 17.
Okay.
Or excuse me, 15, pardon me, 15. And it's regarding when an employee asks for a reclassification or a change to their classification, I believe. If an employee wants to request a change to their classification, the employee makes the request to their director to civil service. And currently civil service has the final decision. And my question is about the process today versus the future. If the director does not agree with the employee's request for reclassification, is the director required to pass it along to civil service today?
Yes, in both cases that would be true. Today it's true, and it would be true under the ordinance as well. The director currently can recommend the employee's request, can endorse it essentially and pass it along. But even if the director does not endorse it, the employee is still able to take that request currently to the executive secretary of the Civil Service Merit Board, and under the ordinance, the employee would still be able to take it to the HR director.
Okay. All right. Thank you.
Are there any other questions? Councilwoman Ryder.
So, Mr. Shields, let me see if I understand this, and I'm learning how all this works. So I may have it wrong. So to follow up on the question from Councilman Smith, if an employee or a director, let's say it's their director, thinks that their employee should be reclassed, they take it, they don't just make that decision. It goes to civil service, and civil service makes that decision. The executive secretary makes the decision, or it goes to the civil service merit board and the decision is made. How does that happen? Or the civil service, the executive secretary makes the recommendation to the merit board and the merit board blesses the decision. I'm not sure how that works. That's part one of my question. I'll let you answer that first.
Okay. I think the answer to your question is the employee's request does go to the executive secretary, and the executive secretary makes the decision. But if the employee disagreed with the executive secretary's decision, and if it was based on some non-merit basis, the employee would be able to take that decision to the full civil service board for them to examine it, to investigate the decision and perhaps to overturn it. And the same is true under the ordinance. What changes is that the decision is not being made by the executive secretary, it's being made by the HR director, but the employee's right, if there was some non-merit based, consideration involved or a suspicion of some non-merit based consideration, the employee would still be able to take that decision onto the merit board for them to continue their function of ensuring that personnel actions are made on the basis of merit.
So right now, if I'm an employee and I think I need to be reclassed, or if my director thinks I need to be reclassed, we take that to the civil service executive secretary, and it's either yes or no. And if we disagree, me, the employee, or the director, I then file my appeal with the civil service executive secretary, or I file my appeal with the board.
So as a practical matter, I'm not sure that that's happening very much. So it's a little murky, frankly. You would ultimately take it to the board. The mechanism that the executive secretary would use to facilitate taking it to the board is not entirely clear. It's not well spelled out. But yes, if there was some aspect of the decision that seemed improper to the employee, something about some political views or some kind of discrimination or some other decision that was contrary to merit principles, regardless of exactly what the if you will, the logistics of how it gets to the board, it does get to the board. I just don't think it happens very often. And so the procedure is perhaps not as fully fleshed out as some of the more common procedures are. But it would remain the same. The board would hear it.
So just to wrap up my question, and I see Janet raise her hand, but so in the future, the way you perceive the way this is laid out to work is the employee and or the director could make that request to the human resources director. And if for some reason they disagreed with the decision of the human resources director, that's when the civil service merit board secretary, executive secretary, director steps in and is the decider, arbitrator, of examiner of whether that was a fair, just, non-political decision.
That's mostly right. I think it would not be the executive secretary individually. I think it would be the executive secretary facilitating the board's review. It would be the board that would look at that. And that's an area where the board's procedures would apply. So you could envision the executive secretary, facilitating that process, but the objective would be for the board to be the decider, if you will.
Okay, thank you for explaining.
Excuse me, before we go to Councilwoman Testerman, I know that we have Vicky Hatfield that's dialed in. So Vicky, could you speak to that as well? I know that Mr. Shields said that he wasn't as familiar with how many of those instances that we have. So if you could speak to that for us, please, briefly.
Sure. Can everyone hear me?
Yes.
Okay, Vicky Hatfield, Civil Service Director. I think I've expressed that this is one of the parts of this ordinance that concerns me the most. A reclassification is a non-competitive promotion. Basically, it's a process where an employee, if they feel they are being worked out of class, that's what this is to correct an issue where an employee is being worked out of class. A lot of employees request reclassifications because obviously it's an easy way to get promoted. You reclassify me, I don't have to take a test, I don't have to go through a merit process. For that reason, the board makes the rules that govern these reclassifications. Those rules are very strict. In my review of a reclassification, first, we only accept reclassifications once a year. It's a yearly process where an employee, if they feel they're being worked out of their classification, they can apply for this. It first goes to their director for a recommendation. That director sends it to us whether they recommend it or not, and we do take that into account. At that point, this is a lengthy process. We spend several months reviewing reclassifications. Each reclassification has to adhere to strict rules developed by the merit board that are in our rules. I will tell you that we get a large number of requests for reclassification. We award very few reclassifications. For example, this year we did 0. We approved 0 reclassifications. The reason for that is because it is a non-competitive promotion. You are promoting an employee without a merit process. So the only instances where these are going to meet the criteria set by the board are typically going to be when the distinction between the job the employee is doing and the job they're being reclassified to is a very fine distinction. There's not a lot of difference. So I'll give you a few examples. I'm a traffic engineering technician 1. I'm asking to be reclassified to a 2. If you look at those job classifications, there's very little distinction between the two. The duties are very similar. That's an employee saying, I've been here for several years. They've given me a tremendous amount of additional responsibility. I now meet the minimum qualifications for this position. I think I've worked up into this second level. Almost every reclassification is going to be that exact situation. We are not going to reclassify an employee to a supervisory position. We are not going to reclassify an employee to a position that should be competed for, posted and competed by other employees. It's literally going to be a step 1 to a step 2 graduation of duties in a job series. And that's only if it meets a strict audit process. We actually go out, we audit the employee, we do extensive interviews, we audit the supervisor, we audit the managers, we audit the director. After collecting all that information, then we look to see, has this employee met the test to move up to that next level of their own job? That's basically what a reclassification is currently. To give blanket approval, blanket authority for a director to make decisions, to be able to reclassify an employee from any job class to any job class without a merit process does not go with Charter 1005 that says promotions will only be made within the rules prescribed by the Civil Service Merit Board. This is giving the authority for a director to award that promotion. I can read from way back in 1980 when the charter was first revised. This was a letter from the board actually sent to the mayor at that time with this exact concern. They basically said reclassifications have to be at the will of the board because the board feels that it's their responsibility to assign individuals to classifications or to recommend to the appointing authority reclassifications of positions and individuals. Without this control, reclassifications may be made to affect a salary increase to an individual who may not actually be performing the duties of the job or may not be qualified for that position. Accordingly, individuals who may be qualified for the position are not afforded an equal opportunity to compete for that promotion. That's why this is an extremely rigid process. It's an extremely restrictive process. Even once we do make a decision to do those few limited reclassifications, we post that for 10 days. We allow other employees to provide feedback. If I'm a similarly situated employee and I feel this is unfair to me, they can make an appeal to us on that behalf, and we may not approve that reclassification on that basis. We may go back to the director and say this needs to be posted as a competitive promotion. So for that reason, we do very few reclassifications. If we were to make a decision that the reclassification was not warranted, or if we did one that other employees objected to, at that point, they could appeal directly to the Civil Service Merit Board. I will tell you that in my 21 years with the city, due to the restrictive nature and how conservative we are with the reclass process, there has not been an appeal since I have worked here.
Vicki, could you just clarify one thing you said? You said you got many requests, but you approved 0. What is many?
Well, this year, I'd have to go back and look at how many we actually got for this year. In a general year, so we opened this process up in October. Anyone who wants to apply for a reclassification must get that in by the end of December. And then we review those because we want that process. If there are going to be reclassifications, we turn that into finance. We work through those with finance during the budget process. And that becomes part of our class comp process with budget. So in most years, we usually get about 20 to maybe 20, 25 requests. In many cases, it's an employee wanting a non-competitive promotion. And in most cases, we go back and recommend that the department post it as a competitive promotion.
Okay. And then another thing that I'm sorry, I feel like I'm going on with this, but you commented on it's a rigorous process and it has a very distinct set of rules. I'd have to go back and listen to what you just said. George, where does it specify how that's going to be done under human resources?
So the ordinance doesn't specify anything on that front because it currently the code also doesn't specify anything on that front. That's all handled through rules.
Okay. Thank you for clarifying that. That's in the Civil Service Merit Board rules, not in the current ordinances. Okay.
That's right. And then I was just going to mention as well, there's nothing in this ordinance that provides blanket approval to directors. The decision is currently at the executive secretary's level, and under the ordinance, the decision would be at the HR director's level. The individual directors of individual employees have a facilitation role. You know, they can endorse it, they can support it, or they could oppose it, but the decision is made by an HR professional in either instance under the current law and under what the ordinance is proposing to do. The difference, though, is that the ordinance separates the decision maker from the same body that would hear one of those appeals. You know, currently the decision maker is the executive secretary, and if you felt aggrieved by that decision, you would essentially be appealing to the executive secretary's bosses. Whereas in the future, if you disagreed with the decision of the HR director, you would be able to take that complaint, assuming there was some merit-based issue, to the merit board, which would be completely independent of the HR director. There wouldn't be any organizational relationship between the two.
Thank you.
Councilwoman Testerman, and then we'll get Councilmember Parker.
Sorry. So I think I'm clear as far as sort of the order or the chain of sort of command, so to speak. In both instances, currently it can still go to the director versus the employee. Can the employee go straight to the Civil Service Board without going to the director at this point?
I think the only way that would happen is if there was some merit-based reason right from the get-go that would make an employee feel compelled to go straight to the board with their complaint. The charter allows for that. There's already, language in the charter that says any employee can bring any complaint that has to do with some personnel action being made on a basis other than merit. They can bring that to the board. As a practical matter, though, I don't think that happens.
Okay, and part B of that question, as Ms. Hatfield was explaining, so let's say an employee feels like they deserve a reclassification. They take that to their director. The director concurs and says, this employee has done a good job. I'd put forth my recommendation for that employee to be reclassified from, in this case, level 1 to level 2. And so is it then at that point, if that reclassification is considered for that particular employee, that it's then turned into a competitive process where other people can apply? Is that how that works now?
I think to answer your question, the way it works now is that if a reclassification is being considered, there's an opportunity for others to comment on that proposed reclassification, but it's not a competition that establishes. I think that's what Vicky was explaining a moment ago. Vicky, you're welcome to amplify on that if you like.
So if an employee is being considered for reclassification, then again, what's that process?
So it's ultimately now it would come to the executive secretary, and she would initiate the process that she described a few minutes ago, involving some analysis of whether it's warranted or not. And as part of that process of determining whether it's warranted or not, there would be an opportunity for others to comment on whether on what the outcome should be, on what the appropriate result would be.
On that specific employee?
Yes, on
By
that.
their peers, essentially?
Anyone having interest in it, anyone who would have information relevant to it, I think is the way the rules are currently worded.
Okay, thank you.
Councilmember Parker.
My question is trying to clarify something said earlier, but under the proposed system with an HR department, would the Civil Service Merit Board rules set the criteria that the HR director would have to follow in determining reclassifications, or does this new ordinance propose that the HR director develop that process, but then appeals and complaints can then be taken to the Civil Service Merit Board?
The brief answer is it's more the latter than the former. The real requirements arise from the charter. The charter says that all personnel actions have to be made on the basis of merit. And so what the Merit Board has done up until this point is flesh that out with rules that go into a little bit more detail. Under the ordinance, those rules would move over to the administrative rules, but I think it's anticipated and expected that the substance would be largely the same. And so it moves where the rules are housed, and it moves who is the if you will, the sort of day-to-day decider. But the appellate process, as you mentioned, still ultimately goes back to the Civil Service Merit Board, which has the final say on whether a particular personnel action has violated merit system principles. That's sort of their unique jurisdiction, is to guard those merit system principles. And so any personnel action that would be contrary to that, there's always the opportunity to bring that to the board.
So the HR department would set the rules.
The HR department individually would not set the rules. The administrative rules are made ultimately under the authority of the mayor. The mayor has to approve all of those administrative rules. The way those rules are made is through a staff process where if there's a recommendation, where something needs to be updated or modified or whatever, it's the staff experts basically who work together to figure out, what the problem is and what the appropriate solution would be. It's vetted through the law department, but ultimately it's presented to the mayor, and it's the mayor who has to, agree with it, to sign it, sort of euphemistically sign it into law, with her signature. So there's a difference in how the process is made. It's never a department individually making those rules. It's always ultimately to the mayor, even if it's initiated in an individual department.
Ms. Hatfield, did you have any additional feedback or comments on that?
I just wanted to follow up to Councilman Parker's question. Just to reiterate something that I find very concerning, particularly with this reclassification portion. I want to read that a reclassification is a promotion. And under the charter, promotions can only be made in accordance with rules of the Civil Service Merit Board. It cannot be made in accordance with rules set by the mayor. So the reason we can do a reclassification today is because the Civil Service Merit Board has rules that allow that and govern it. Once those rules are taken out of the Civil Service Merit Board rules, you cannot do a reclassification because now you're doing a promotion outside of the Civil Service Merit Board rules, which is not allowed by charter. I also want to point out, George has spoken extensively about the rules that will be promulgated, but in section 2448, section 11, section 2448 of the ordinance, section 2458 and section 2459, this proposed ordinance removes the requirement. Currently, there is a requirement that council put in here. There's a requirement that we will promulgate rules. That's in 2448, 2458, and 2459 for general government, fire, and police, respectively. You direct us to promulgate rules. Those are deleted. There is no requirement in this ordinance that they promulgate rules. They may or may not have rules, but there's not a requirement.
So let me speak to that. The ordinance actually does say very clearly that the intent is to transfer those rules, not to eliminate the need for rules. You can find that in the whereas clauses, for example, where we're stating expressly that the idea is that rules will continue to govern these. It's a difference in who makes the rules. There's also, to make the background clear here, the reason those requirements are in the code right now is because when the personnel department went away, there was no other body to govern those rules, to have a part in making those rules. When we had a personnel department, the Civil Service Merit Board did not make those rules. And I think that indicates that there must have been some understanding at that time that a reclassification was not exactly synonymous with a promotion. Otherwise, it would be called a promotion, but it's called a reclassification. And the code recognized that when we had a personnel department, it left that responsibility to the personnel department. The only reason those rules are currently being made by the Merit Board is because the Merit Board, the Merit Board can't make its own rule any other way other than through its rulemaking authority. There's no way to sort of have a halfway transfer there. If the whole responsibility is going to move to the Civil Service Merit Board, it had to be done using its rulemaking power. It wasn't a decision by the council in the 80s that it was inherently a function of the Civil Service Merit Board. It was a practical decision so that someone could make those rules and administer those rules. And that was the language that had to be used to effectuate moving that responsibility over.
Vice Mayor, could I just make a comment or make sure I understand everything? I mean, my understanding is that the Civil Service Merit Board sets the rules and administration administers the rules. And if we break the rules, people could bring it to the Civil Service Merit Board to say they're breaking the rules, please, make them stop, and then they will, and they're an independent board. And then if we want to change the rules, like let's say we want to change the rules for how we recruit police officers and let them be able to apply online from California instead of flying to Knoxville. If we wanted to change that rules, it wouldn't just be like, oh, Mayor Kincannon said so, the HR department wrote the rules up, it's done. We would bring those rule changes to the Civil Service Merit Board, say, we want to do this. Please review this. Let us know if you think it still meets our principles of non-discrimination and merit and all those protections. They would review it. If it meets it, and then they would say, yes, this meets the merit protection standards or not. We want you to amend it in this way. And then once it's approved, then it's like, now we can test people in California, or for example. Is that, so I think maybe it's a language thing. The Civil Service Merit Board still sets the rules, administration administers. If I wanted to change the rules and had an HR department that would give me suggestions for what our rules changes could be that would make us a more modern, efficient, talent recruiter and retainer and all those things. I couldn't just do that without going through the Civil Service Merit Board. It was still, rule changes would have to go to them for review, or am I understanding that?
Mayor, the answer to your question is a little complicated because some of the rules are in one set of rules and some are in the other set of rules. For those rules, though, that are made by the Merit Board and that would continue to be made by the Merit Board, you're exactly right. You wouldn't have any authority on your own to change those. So for your recruiting example, recruiting is something that the ordinance leaves with civil service. So when it comes to deciding what the appropriate procedures are to make sure that all potential recruits have a fair chance at the job, that would be the Merit Boards to decide. If there was something in those rules that you felt were out of step with your objectives, you would take that request to the Merit Board and they would make the change or not, because that's something that would stay with them. So
so what are the kinds of rules that would not be in the purview of the Civil Service Merit Board under this ordinance change?
So broadly speaking, issues involving classification and compensation would move back to HR because that's where, when we had a personnel department, the Merit Board wasn't making those rules at the time. It's part of the management function to define what the jobs are and to to budget the salaries fundamentally. That's the philosophical basis for it.
But right now those rules don't go to the Civil Service Merit Board anyways. Just as Ms. Hatfield said, when 25 people have submitted requests for reclassification, there's been 25 denials, 0 appeals. I don't think people even know that they have an opportunity to appeal. It just ends with the civil service staff. So there'd be no difference in that, except instead of ending with the civil service staff, it end with an HR staff. But we could make it more explicit that if someone's unhappy with the outcome of the HR, we could change the thing that Andrew Roberto and Lauren were saying, on page, whatever, I think it's section 13.
You're exactly right, Mayor.
We could make it better than it is now. We could make it so instead of 0 appeal, there's a more explicit rule. I'm looking on page 7 of the ordinance, section 13, the very last line. This is an issue that I think employees have found to be problematic, and council members and me too. So this is, to me, this represents the status quo. There's no, the decision of the department shall be final without right to appeal. That's sort of the way it is now, except instead of HR, it's civil service. So, not civil service board, civil service staff.
But according to Civil Service Board rules.
I'm not sure. I don't think it's in the Civil Service Merit Board at all. I think it's just staff. But George, I'll let you.
So Mayor, your example is correct. Right now, for all intents and purposes, the executive secretary's decision is final. And she makes that decision on the basis of rules that the Merit Board has made. But as a practical matter, no one is taking an appeal to the Merit Board. It's the individual executive secretary's decision that controls the day. What the ordinance would do is move that decision over to the HR director, but still, as is already the case today, but is apparently not exercised, if the HR director's decision was contrary to merit principles, not necessarily just the letter of a rule, but the principle of the thing, the idea that merit is what controls our personnel actions, the board always has the ability to hear that. And
so if someone said, my classification upgrade was denied because I'm Black, or because I'm a woman, or because my supervisors doesn't like me, they could appeal to the Merit Board. That would happen under the new ordinance, or in theory, it could happen now. It just doesn't.
That's right.
So we could change the ordinance language to maybe make that more explicit, or just somehow put it in an employee handbook or something, because I think that's a real concern of employees, being able to appeal that if they think it was unfair. If the reason is that they're not actually doing that job and they're just trying to circumvent they're trying to get a promotion, that's not a merit issue, that's a different issue.
You're right, Mayor. So the ordinance and the charter are supposed to talk with each other. And so that's what's happening here. If it's easier and clearer, though, to sort of repeat what the charter is already saying in the ordinance, we can certainly do that.
Thank you. Let me go to Council Member Ryder.
Okay, so I have a question for Ms. Hatfield, I think. and we've been talking around this, and I just want to make sure that it's clear. So I have an experience with, we keep talking about reclassification and calling it promotion, and I understand it why you're calling it that, but I'm not going to talk about a city job. Okay, so if somebody is crossing guard level 1 and they want to be a reclass to crossing guard level 2, okay, I'm making these things up, but you know, you want to get bumped up in class because there are certain merits. I'm not looking at your system, so I may be speaking off on that, but there's certain job functions that you do as level 1. And if you do certain job functions, you're level 2. And there's a pay range associated with level 1, and there's a pay range associated with level 2. If your job changes and you're doing things that you believe puts you at level 2, you or your supervisor might say, I'd like to be reviewed for reclassification because I believe that the functions that I'm performing are actually in keeping with level 2. So I just wanted to make it clear or have you clarify that this isn't just people saying, I've been here for a certain amount of time, I feel like I deserve a promotion. It's, does the amount of time and percentages that you spend doing a certain thing put you in level 2 versus level 1? I've had this personally happen where I had an assistant that I felt was doing supervisory functions. And so when we did an evaluation of the position, a reevaluation on a reoccurring basis, I made a point as the supervisor of writing up and saying, this person is doing these things, which I would like a review for to see if that bumps them up. That is how that's what a reclassification is, correct?
That sounds like a pretty good explanation of it.
A layman's explanation,
yeah,
maybe?
Typically, if one is going to be approved, that's what it's going to be. I would like to note that in our rules, in the Civil Service Merit Board rules, one of the things that it's very specific about is that in the determination of a reclassification, it's the intent of our rules to provide guidance and guidelines for monitoring these to ensure that merit principles are not circumvented. The basis of the reclassification must be gradual. It can't be a sudden change in a job, basically just to circumvent the merit system. So yes, we use the terms interchangeably. We refer to these, we have always referred to these as non-competitive promotions. That's why I use the word promotion.
Okay.
Because it's always, you don't get reclassified laterally and you don't get reclassified down. And a promotion in our system is defined as an accretion in pay grade. But to note that, you know, to meet that test, one of the requirements that we have always required, and this was something that we agreed on in cooperation with the finance department some 15 years ago, is that three things have to be met for a subsequent classification to advance to another classification. Time in class cannot, currently under our rules, time in class cannot warrant a promotion. It has to be a combination of time in class. There have to be additional educational and training requirements added. We're not just going to have a tenure-based promotion system. So it also, we have to bring added value through education and training and certifications. They have to meet that as well. And there has to be an accretion of duties and responsibility. So all of those are currently housed and governed by the civil service rules. And we require all of those things to be met prior to someone advancing.
Okay, so follow-up question to that. You, the Civil Service Merit Board, don't just come up with these rules. Do you have some kind of, is there an overseeing body? Is there a national organization? What monitors what your rules are? How I don't understand.
Well,
or
so
help
what
me
I can tell
understand.
you, yes, what I can tell you is most of these rules, so we had a body of rules when I came here.
Okay.
So I can't tell you where the original set of civil service rules came from. But anytime we make a new rule or we make an amendment to a rule, I basically, the board typically looks to me for that guidance. And I've been an HR professional for 23 years. I have a tremendous amount of experience. We work with MTAS very closely. We work with the Tennessee Personnel Management Association very closely. We coordinate closely with agencies like Wimberley Lawson. So we reach to all of those resources in just looking at best practices, best HR practices to ensure that our rules, meet our needs, preserve our merit system principles, but also are consistent with HR practices.
Okay.
Do we have any other council questions? Councilman Roberto, then we'll go to
Thank you, Vice Mayor. Yeah, I mean, I think we're hitting on the big points here that, I think need to be addressed. One being this, section 11, which is about the rulemaking. And I think, again, if I understand George's answer to my question correctly, and using the mayor's example, you have compensation and classification rules. The current system would be that would be, if there were any changes made to them, it would be in a public meeting, publicly noticed. That is not addressed in the ordinance. It's part of the rules. And I think the follow-up to the ordinance would be the rules. And in the rules, you would be able to specify that, the same procedure that goes on with public notification and a notice would go on. That's not in this ordinance. And so one potential way to deal with that would be to bring the rules with the ordinance. And that way everyone can see what the initial rules will be with regard to reclassification and these plans. And you don't have to wait to see what happens there. But I do think it's important to, if there are going to be changes to any of the rules, to make sure it's publicly noticed and give a comment period, so that if employees find that, find out that something came up and didn't know about it, I don't think that's where we want to, I don't think that's the intent of anybody. Now, keeping in mind that the charter provides for extensive investigatory powers of the Civil Service Merit Board. So even if that did happen in that way, they could investigate it even with subpoena power. I don't think we want that to be where we're going. So I would, again, part of the discussion today is about, improvements that we can make. Maybe bringing the rules with the ordinance is a good idea. So I don't know, George, did I get that right?
You got that right. That's exactly right. That's addressed at a lower level of law right now. It's not addressed in the ordinance. It's addressed in rules. And your analysis is correct.
Okay. I had a couple of questions, and I'm happy to let Councilperson Smith go first, but I had a couple of questions for some of the representatives from some of the employment associations. I don't know, Vice Mayor, if you want me to do that after Mr. Smith's question, or do you want me to go ahead and do it now?
If you don't mind, let's let Councilman Smith give his question, then we'll come back to you. Thank you.
Ms. Hatfield, I thought I heard you say that the rules themselves being maintained within civil service are part of the charter. Is that what you were saying earlier?
No, so the civil service rules. So the charter requires the Civil Service Merit Board to have rules on certain things, and our requirements for notice, 10-day notice, public hearing, that comes from the charter. Council has currently placed the rules for classification and compensation within the civil service rules through the code.
Okay, thank you. All right, thank you.
Any other council members? I have Councilman Roberto, if you don't mind, I'd like to let Councilwoman Fugit ask her question.
Absolutely.
Thank you. Vice Mayor and Councilman Roberto, because mine goes to follow up that question. So if the rules are made by the Civil Service Board, the Civil Service Board can change the rules. Correct? So they could publicly notice and change the rules at any time.
That's correct.
Thank you. Councilman Roberto.
Oh, thank you, Vice Mayor. I'll start with Kevin Faddis with the Firefighters Association. And actually, I'm going to ask each of you the same question. So, Kevin, you get to be the first one to have to answer it.
The hot seat, is that what we're going to call it? The hot seat?
Yes, that's what we'll call it. Hey, given your experience, what I wanted to ask you about is, can you talk to us about your experience with the current system? And then after you talk about that experience, can you tell us about things that you might want to see changes in the future, or what the process in your mind would look like in the future?
Sure, I appreciate it. My name's Kevin Faddis. I'm Knoxville Firefighter Association president. So thank you for having me on here. First of all, I want to say I completely like this dialogue. Things that you hit on, Councilman Roberto, things that you hit on, Councilwoman Testerman, and you guys have really, and even Ms. Hatfield and the mayor, I can see where this is being hashed out, and I certainly enjoy this, and looking forward to it. But some of the things that I've experienced, it's almost like I don't want to say a redundancy, but it's some of the things that I do like about the civil service in itself is the protections of the employees, absolutely, first and foremost. And while we were discussing this, some of the language that Mr. Shields put forward, well, Mr. Roberto put forth that Mr. Shields concurred with, I think those are going to put some of our employees at ease. So thank you for bringing that up. Employee protections and the way they dole out discipline from that end of it, I think that is a pertinent role of the civil service or the merit board, so to speak. Some of the things that we've had issues with, of course, are I don't really want to say transparency, but it's kind of like that because we don't absolutely know, I think, everything. And maybe part of the reason is we didn't ask. But I had no idea, we had no idea how much control that the Civil Service Merit Board actually has. We thought some of these things fell on the executive secretary, which some of it does, absolutely. But I mean, so what we would like to see is like the compensation go to HR. HR can monitor that on a daily basis, on a weekly basis, on a monthly basis, follow the trends, see what's going on. I don't think, and it's nothing against the civil service employees, I don't think it's something that they can actually efficiently do every day, every week, every month. I don't know that they're doing it. So the HR function of that, I think, is very good for the city, very good for civil service. It's a checks and balances, and that's what I've been hearing tonight. I know some of the language is kind of off, but I think we can get there. I truly do. So those are just some of the issues that I've had: is the pay, the compensation. I did have a question though. Is it always made public? For instance, that Councilwoman Ryder brought up. Is it always made public for the executive secretary to make a decision on one individual, so to speak? Let's say you had Cabana Boy 1 wanting to go to Cabana Boy 2. Is that one individual, is that always made public, or is that something, since there isn't a competition, so to speak, is that something just made within the office? So I hope I answered your questions kind of the best I can. I'm still here if you got any more.
George, do you want to address that?
I'll be glad to. According to the Merit Board's rules, the posting of a reclassification announcement, in other words, the public component of that process, occurs after the reclassification decision has been made. So it's sort of a final step before it becomes a locked-in classification. There's one last chance to make sure there's not some issue that others would be able to bring to the attention of the executive secretary. The analysis, and for all intents and purposes, the decision is done barring some new information. So if the decision is not going to result in a reclassification, there would not be an announcement that it was even being considered. It's only if there is going to be a reclassification and there's one last chance, for contrary information to be provided.
Kevin, I know you're probably signed up for a public forum, so I just wanted to hear from you about your thoughts on that, and we can save further comment going forward. If it's okay, I'd like to ask Ben Buckner the same set of questions. He's with the City Employee Association. Ben, are you there?
Yes.
Can you follow up on what Mr. Faddis talked to us about with regard to your experience with the current process and what you'd like to see going forward with whatever process we might adopt?
I think the process we would like adopted is just clarification on employee protection. That's the biggest thing I keep hearing from a lot of people, is to make sure we are protected under civil service, and to where we can't just be reclassed for no reasons and for any particular like political reasons. You'll hear that a lot. So.
Thank you. And then I know Keith Lyon isn't available with the FOP, so Mark Taylor, are you there? Are you there, Mark?
Mark, if you would raise your hand, if you're dialing in, you could select *9 to let us know that you're here. I don't see you. Nobody's raising their hand.
Okay. Well, he may not have been able to dial in. That's all I have, Vice Mayor. Thank you.
Okay, thank you. Councilwoman Testerman.
So I've heard two things, just to clarify. I've heard from Ms. Hatfield that reclassification is synonymous with promotion, but from what Mr. Buckner just said, that the fear of the employees is that reclassification almost also must signify to some level demotion. So I'm just trying to make sure I understand really what the terminology of reclassification is across the board, or what everyone's interpretation is of it.
I'll be glad to speak to that, Councilwoman. Our charter is very clear that demotion is the result of a disciplinary action. It can't be accomplished other than through a disciplinary process that requires notice and an opportunity to be heard. It could not be done, so to speak, through the back door, through a classification issue. It's solely a disciplinary matter.
Okay.
Mark Taylor is now here. Well, he was. Yeah, he is still here. Do we want to hear from him?
Great. Mark, are you there?
Sorry, I think I was muted.
Oh, there you are. Well, I don't know if you had been tuning in, but I had just asked some questions of Kevin Faddis and Ben Buckner, and I'm going to ask you the same thing.
Yes, sir.
Can you talk to us about your experience with the current process, and any changes or what you'd like to see in a future process that we might adopt?
Well, and my name is Mark Taylor. I'm the immediate past president of the Fraternal Order of Police Volunteer Lodge 2. I was the president for about an 8-year period. So I have a bit of experience with the process, with civil service, with compensation, stuff like that, and with the administration. And I guess, I am a proponent of civil service, and I've used civil service processes and as ways to try and resolve conflicts over the years on multiple occasions to varying degrees of success. So I would first off want to do nothing that would take away an employee's rights to any equity processes or anything like that. But I think specifically in my line of work and in police, that there are big issues with the current system as far as its ability to adapt and its inflexibility to meet the needs of recruiting and retention and just those things that we need to get back to where we have the proper staffing and to where we can function again.
Thank you very much.
Okay. Are there any other questions or comments from council at this time? Okay. If not, I have a couple. Okay. Councilwoman Ryder, go right ahead.
Do you have questions? Because I can wait. Or
I have a couple, so I'll let you go ahead.
okay. Well, I just wanted to ask. So, Ms. Hatfield, for everyone who on council, I have no idea who from council was able to watch the Civil Service Merit Board meeting yesterday. If you were not, I hope that you got the link, and if not, Ms. Hatfield will provide that. I think that was important for everyone to watch. I watched it twice. And Ms. Hatfield, when will your next Civil Service Merit Board meeting be?
We actually do not know.
Isn't it regularly prescribed in your rules?
The normally scheduled meeting would be on May 13th, but we think we're going to have to call an earlier meeting. So we're discussing that right now. So we have not made a decision on that yet. But if it's our regular date, it would be May 13th.
Thank you.
Ms. Hatfield, do you have anything else that you'd like to share based on what you've heard to this point?
I have so many things to say, but I'm going to hold most of them in. I just wanted to do a couple of follow-up comments to some of these statements that were brought to you by the employee reps. George is correct that a reclassification as defined in our rules would not include a reduction in classification. I don't see how under any circumstances that could be done without being considered a disciplinary demotion. So I think that answers Ben's concern with regard to a reclassification. With regard to both Kevin and Mark's comments about compensation and recruiting and retention, I'm just going to direct all of you to the data that I provided you. I think you have that. I don't know if you've had a chance to look at it. But it's important to note, I think there's a huge misunderstanding about what we do and how much we do, how many metrics we pull on a regular basis, how many of those we study, the reports we generate, the reports we share, have shared with our mayors on a quarterly basis, an annual basis with departments. I actually pulled one on my own initiative for Chief Thomas just back in January to show her how we ended up where we were in that situation with having a difficulty recruiting for those academies, and what things she and I have already done to improve that. And you can look at that data. There was a compelling reason why between 2014 and 16 that situation occurred, and you can see that through really aggressive means, we're already reversing that trend. We are almost back to being able to fill the requisitioned number. We're very close with this April group. So to suggest that we don't do that, I just want to clarify that we absolutely do that. We have a lot of trained professionals with regard to compensation, but I did give you all of that recruitment and retention data so that you can see that is something we do. We monitor compensation on a regular basis, even in years that we're not doing a survey. So I'm happy to provide any of that at any time.
So
Yes.
can I ask Vicki about a question about compensation? So you guys do a compensation study. Some of that is in ordinances because we've voted on changes to the frequency of information from other cities. And that's how the pay ranges are come up with for different classifications of positions. Is that correct?
Yes. So until 2 years ago, we actually did a survey every single year. That is unusual for a municipality, but because of that, we've become extremely well versed in it and very experienced in it. So we've done a large number of surveys. We've done 2 comprehensive surveys with consulting firms, including the Mercer compensation study and the Siegel compensation study in 2014. And I have recommended on more than one occasion that because we're doing that, we've done those every 6 years, that because 2020 is a survey year, it would make sense to potentially look at doing another consultant survey this year. I know that police and fire have raised questions about compression that would give us an opportunity to see if that compression actually exists and what could be done to alleviate it. They've expressed a desire to go back to a step structure that would also address that and allow us to redesign a step structure for them, and just take our pulse and look at our market rates. But I guess to me, you're just taking it from one entity and putting it with another. I don't see that you're not going to be gaining something you don't already have. We already do that, and we do it in a very professional manner, and we have a lot of education and experience at doing it.
So my question, let me see if I can convey to you what my question is. Salaries aren't arbitrarily decided. They're based on market data and surveys. And you provide that as a recommendation. I know I've been on council a couple of years. That comes to us, but it also goes to the administration. Is that correct?
Yes.
And what happens at that point with it's a recommendation from you. Is that correct?
So here's how that process works. And I will respectfully disagree with George in that there is a classification plan and a compensation plan. In the HR profession, you have a class listing, and that's going to house your job classifications and those specifications and descriptions. You're also going to have a salary structure. The combination of those 2 things is your class comp plan. It is one plan, and they do work like this. That's what we bring to council. Job classifications don't come to council. That would wear you out if we had to bring those every time we changed or amended a new job description. What comes to council is the class comp plan, which is a single plan, and it's where you intermarry all of your job classifications with your 3 salary structures. The way that we monitor that and make amendments to that, we do collect data. Even in years we don't do a comprehensive survey, we're always collecting data. Right now, I'm actually doing a targeted survey for traffic engineering. They want to do a comprehensive reorganization of their parking meter, sign shop, and signal shop. So we're actually working with them right now to do a targeted classification compensation survey to look at how best to help them reorganize and develop better career paths for those employees. So we do that regularly. When we do a comprehensive survey that looks at all 3 structures, general government, police, and fire, at the conclusion of that process, so we conduct our own survey or we hire a consultant to do it. In the years we've hired a consultant, I work closely with the consultant. We basically do the survey together, and I'm there with, they don't just do a survey and hand us a product. Even in those years, we're working with them on every single step. We help them design the survey, we help them look at the data. We work on every piece of that. So when we finished that process, I then look at it initially for recommendations under the classification compensation plan. Do our structures themselves need upward adjustments to better reflect market rates? Do individual job classes need to be readjusted? Do they need to be in a different pay grade? Do they need a better job title? That's why I say it's a class comp plan. The whole thing works as one. Once I take a look at that and determine some initial recommendations based on my experience doing those, I then sit down with the finance director. That's usually step one, because I want to say, here's what it looks like we need to do. And this is what we've done. I've been doing this for the city for 15 years, this part. Every year I sit down with the finance director, usually in February. I go through what, based on the data, look like the ideal recommendations. If we could have our wish list, here's what we need to do. Then the finance director and I work on those together to ensure that they're going to be agreeable with the budget. Sometimes it's something that, our wish list, we simply can't afford to do it. So we look at that together at that point and work on a final set of recommendations that meet our best needs, most important needs, and still come in with responsible budget considerations. Once the finance director and I have something that we both feel meets the class comp needs and the budget needs, we then establish a meeting with the mayor. We sit down and propose our joint recommendations to the mayor. In past years, this is always, usually it's a couple of meetings to ensure that the mayor has any data that she needs, understands the recommendations, has an opportunity to ask any questions. It's always been a very cooperative, collaborative process. Once the mayor has had an opportunity to understand, review the recommendations, in my 15 years, I've only had one instance where the mayor wanted different recommendations. That was last year with the 7.7% increase for police. That was the only time in my tenure we have not arrived at a general consensus. That was just a last minute change that was inserted into it. So certainly, usually it's a collaborative process. We all are in agreement before that ordinance is even drafted and goes forward. But it is at the mayor's prerogative to add to those recommendations if the mayor feels there's something that is a priority, or she wants to add an increase across the board. Certainly the mayor then can ask me to add those into the class comp ordinance.
Okay, thanks. So you bring a recommendation and you come to a consensus. It's not something that you come to within the Civil Service Merit Board.
Correct.
Thank you.
Mr. Shields?
Thank you, Vice Mayor. I just wanted to correct, it may be civil services practice to treat classification as compensation as though they are, they're too intertwined to be thought of as separate, but that's not what our charter says. Our charter treats them as separate. And that's important because, again, going back to when we had a personnel department and we had a civil service merit board, all under this charter that we're operating under now, it was recognized that compensation was the function of the personnel department and the mayor and finance alone. But classification was different because that does impact, the fairness of the task you're assigned to do and the nature of your work. And so it was recognized then that the merit board had a role in monitoring classification to make sure that those merit system principles were being followed. Compensation is a budget process, and that's why the personnel department managed that process when we formerly had it. Classification is a management process first, unless it's being done unfairly in some way. And that's why the Civil Service Merit Board can monitor it. That's why our charter treats them as separate, because all of the rights and issues that flow from them are separate.
I'm sorry, I didn't realize I was on mute. I was asking, are there any additional, thank you, Mr. Shields. Are there any additional questions or comments from council? Okay, I'll go into my.
Ms. Parker had a question.
Sorry, Councilmember Parker.
Sorry, I just wanted to comment that it's clear from tonight's discussion that there are a lot of pieces for us to understand before voting on this matter. And that includes even legislative history going back 40 years, which there doesn't seem to even be agreement on that history and why these changes were made. I'm concerned that we're going to need more time to understand this. I know many folks, we're all aware that there are many city employees who want to be a part of this discussion. And I imagine many more city employees who would have signed up for public forum so that we could better understand their concerns if we had a different setting. And it was really concerning to me yesterday during the Civil Service Merit Board meeting that, a member of the board with 30 years of HR experience was himself overwhelmed with all of the information coming in on a daily basis, it seems. And so not able to provide an opinion on this proposed ordinance during yesterday's meeting. So if someone with 30 years of HR experience needs more time to review this, I think we as a city council need more time, and certainly city employees, deserve time and space to give feedback and input on this process, which is different than individual calls. It's different having a one-on-one conversation with the city employee versus us as a group hearing that feedback, so we're all hearing the same thing. So I don't know where we go from here. We have the workshop today, and then our next conversation on this is not for 6-7 weeks. And we're not going to hear from the Civil Service Merit Board as a body until that voting meeting. So my hope would be that we would be able to hear from the Civil Service Merit Board as a body before being asked to vote on this ordinance in June.
Thank you, Councilmember Parker. And we can certainly look at scheduling some time, maybe an additional workshop with council, if we can find availability to actually hear from the Civil Service Board members. I have a couple of questions and comments that I'd like to make. At this point, I would like to ask, what has the communication plan been to the employees related to the changes that we're talking about enacting in establishing an HR department? And so, Mayor, I don't know if you or Mr. Shields can speak to that.
Well, I'll speak to that, and maybe if Mr. Shields has something to add, that's fine. The communication has been with in-person meetings, and then since the pandemic, it's been these kinds of meetings, Zoom meetings. I've had a couple of those. I wanted to hear from council members at this workshop before scheduling the one. I'm planning to have at least 3 more, one for police, one for fire, and one for general government, because while some of their concerns are just, consistent, and some of them might be particular to their area of government. So those are going to be planned in the coming weeks. And I do appreciate that your willingness to we postponed this at the last council meeting, and I think that was a good call, because I think that council members have had some questions answered tonight. Civil Service Merit Board had a good discussion yesterday, but they have time to meet again. They meet again in May, and they can have this on their agenda if that's what they choose to do, and then they can bring any feedback that they want to City Council, at one of your meetings, and all before you vote on this. So, yeah, that's my communications plan. I mean, I've been, sending some emails, and Mr. Hatfield has sent a few emails as well, and shared FAQs. I've answered questions, personally questions by email and phone, but the broader communications plan is to have more of these Zoom meetings. I would do more in-person ones, but that's just not possible right now.
Right, totally understand that. And so in those meetings, do we have civil service, anyone from the Civil Service Merit Board or Civil Service that maybe sits in on those meetings to address any questions, or to maybe help employees feel like this is more cohesive as far as the transition?
Yeah, well,
Because-
what I pledge to do is to have the meetings and have them be open to the public. And I'll make sure members of the Civil Service Merit Board are aware of when those are. They're not secret meetings. And I'll work with our IT people and communications people to do it sort of like whatever we're doing now. I want to set it at a time that's first and foremost convenient for employees, but then invite the media, invite the Civil Service Merit Board. You know, it'll be public similar to what we're doing with this meeting now. So people, I guess we're watching live on YouTube. It can be recorded and posted to the city website, but also people can watch it while it's happening as well.
Okay, thank you. Also, Mayor, you mentioned in your opening statements that employees have questioned the integrity of civil service in the past. Have you seen that in your administration? Are you speaking to past administrations? Mayor, you're on mute. Mayor, you're on mute.
Sorry.
Okay.
I'm just looking back at what I said, and maybe I misspoke. What I meant to say is that it's critical to protect the integrity of the crucial civil service function, not that people question the integrity of the civil service itself.
Okay.
I didn't, if I said that, I apologize, I misspoke. I do not have any experience of that. I think people in general think the civil service does a good job, and it's just difficult to wear two hats, and that's what the challenge is.
Okay. And then also you had mentioned that there's been some due diligence that was done across the state with other municipalities regarding civil service versus HR departments. The feedback, were you able to get any additional feedback as to, you know, how long they've been in place, background, how long have those been in place? What's been the feedback?
Well, this was a survey that MTS did, and you know, they got the responses, like I said, from about 20 or so entities, but it's been, I think right now might be hard to get people to answer more extensive questions about the history of it and all. So I can ask MTS if they could send that survey, but if they're anything at all like how busy we are, it's not going to be, I'm not expecting a high response rate, but I can ask, and I think what's important to note is that we are really, what's unique about us is that we do have civil service. We do have merit protections, and that's something that's unique, almost unique to Knoxville. There's only 2 other cities that have that. And I think that's something that's really important. It helps us be a strong employer. It helps us, you know, protect from discrimination. In other cities, a mayor could be elected and just fire people who had a yard sign for their opponent in their yard. We can't do that here, and that's a good thing. I think patronage is bad, nepotism is bad. Hiring people and firing and promoting for anything other than merit is not acceptable. And I think that's exactly why we have the civil service protections, and that's why I don't want to change that at all. But I think, as I said at the beginning, our employees need more than just protection, the merit protections. They also need those HR functions, the recruitment, the retention, the training for our managers, and all those things. So it's not, I want to keep civil service and all those protections and strengthen the HR side of things and have them be 2 separate functions, because one sets the rules and the other administers the rules. And we need the civil service to act as that watchdog to make sure not just my administration, but all subsequent administrations follow those rules.
But can we clarify though that under this ordinance for compensation and classification, the HR department would set the rules?
Mr. Shields, can you clarify that for us?
Yes, so under this ordinance, those rules would return to the administrative rules. They would not be made through the civil service rules, because they're only now being made there because there's no personnel department. But even then, civil service has an overarching authority, even if they're not making the rules. They have an authority to hear complaints, conduct investigations, and order remedies on any violation of merit system principles, regardless of who the author of the rules is. And that part could not change.
But we cannot say that Civil Service Merit Board makes the rules and then another department is administering them.
It's my, Councilwoman Parker, it's my understanding, and Mr. Shields, correct me if I'm wrong, that civil
he
service.
just stated it.
Okay, that civil service would continue to make all the rules about merit protection. And right now, the classification and compensation rules are not really made by Civil Service Merit Board. It's just made by the executive secretary and her staff. And it ends there. It doesn't go to the board for review. And now it would go to HR. So it's not, but like I said, since there's so many concerns, and I share them about an appeal process and what the charter allows, we can put in the ordinance that fix that thing on page 7, I think it was, where we can clarify in there that people that could appeal, if they feel like they've been discriminated against, they could appeal to the merit system. They could appeal through the merit system to the Civil Service Merit Board. So that's as clear as I think I know how to make it this evening anyways.
Let me ask go right ahead, Mr. Shields, and I have a question, a clarifying question.
I was just going to try and clarify that. The Merit Board's rules are doing two things. Some of those rules are merit protections, but a lot of them are the day-to-day processing of a request or the handling of an issue. It's setting out the steps, if you will, that a particular issue is handled through. The part that changes is the administrative part, the who and the how and the when type stuff. The merit protection part is something civil service can always make rules on because that's their core charter function. So even if the administrating rules are being done separately, civil service could still maintain rules that address inequities in how that administration is being affected. If there's some non-meritorious aspect of that, they can make rules designed to remedy that. It's a distinction between who's doing it on a day-to-day basis and who's monitoring it. And the rules would have a different focus if they were split between those two separate groups.
Okay, so let me ask a clarifying question, and Ms. Hatfield, you may be more appropriate to answer this one because I keep hearing reference to the executive secretary and just recently the executive secretary and her staff. Are we talking about, is her staff the Civil Service Merit Board?
Vicki Hatfield's official job title is Executive Secretary to the Civil Service Merit Board. And then she has a staff. And the Civil Service Merit Board are 5 volunteers who they are, essentially they're the board that directs Ms. Hatfield in her capacity as Executive Secretary for, whatever direction that she needs. And then Civil Service has staff members. I don't know how many, 12 or something. I'm not sure exactly how many. I'm sure Ms. Hatfield can tell us. And they are City of Knoxville Civil Service protected employees, many of whom do civil service functions, some of them whose job titles are, they do HR functions. So those are the paid staff who process, some of them are the ones who do the work of the personnel, of the old personnel department. Say, for example, when someone wants a classification, that doesn't go to the board. That goes to the civil service staff, and they review it and apparently, typically deny it for the reasons Ms. Hatfield explained. And then it ends there. So when I say civil service staff, I mean actual employees of the City of Knoxville who work in the Civil Service Department, and their boss is Vicki Hatfield. And Vicki Hatfield's boss is the members of the volunteer members of the Civil Service Merit Board.
Okay. Ms. Hatfield, do you want to add anything to that? Or answer how many staff members you currently have, please?
Yeah, I just wanted to clarify a couple of things that were a little misspoken. My official title is the Civil Service Director. That's actually what is in the code. That's what's in the class listing. I serve as the Executive Secretary to the Civil Service Merit Board, but that job title does not actually exist in our class listing. I do work for the board. I report to the board of 5 members, and all of the actions that I take are subject to that board. I do have a staff of currently 11 people. And one thing that the mayor said that I don't know if she meant it this way, but it came out a little confusing. She stated that currently the rules are not subject to the board and that they're made by me. And that is not correct. I think what she meant to say, I think she was just referring to the reclassification process. And all of our rules, all of the civil service rules are subject to the board. I don't have authority over the rules. I administer those rules on behalf of the board. Those rules are subject to the board. And to kind of speak to something that Councilwoman Parker, I think, was trying to point out is that certainly there are certain rules in there right now that are not charter driven. They're not in the Civil Service Merit Board rules because the charter says they have to be. However, what I think is important, and I think it might be one of the reasons you've heard from a lot of employees, is because 35 years ago, council decided to put those rules with the Civil Service Merit Board. By doing that, you gave a tremendous amount of added protection to employees. Police and fire employees cannot have the minimum requirements for their jobs change. If I'm a senior firefighter and I want to promote to master firefighter, those requirements are housed in the civil service rules. They can't be changed without going before the board and without me as an employee having an opportunity to go speak to those rule changes. That gives employees an added layer of protection. All of those class comp rules give that added layer of protection, and employees have come to count on those in the last 35 years. So it is alarming to suggest stripping those away and placing them with a different entity that has maybe not the same level of protection.
Okay, thank you. Councilwoman Ryder.
So to follow up on something that Ms. Hatfield just said about changes to maybe the base requirements for example, a police or firefighter, I would actually like to refer to, and maybe this is a follow-up for later question, to Captain Thomas or Chief Sharp, or maybe I got that backwards, sorry. But in my work, we have accrediting agencies that determine factors like minimum requirements. Like, in other words, for insurance and certifications and accreditations, like you have to have employees with a certain amount of experience or education or training. I mean, isn't that the case? It's just not arbitrarily decided. There's accrediting agencies that oversee your employees' basis for being able to do that job. It's not based on what the supervisor feels like.
May I respond?
Sure.
Okay.
Yes.
That's exactly right. And especially when it comes to hiring, we have certain post peace officer standards from Tennessee requirements that we have to meet in the hiring process. So, we have to have a medical, we have to have a psychological. So even just the minimum requirements for police officer, there are some outside entities that determine what's required to be a police officer. The promotional process that's in place, the way we have our promotion set up for, you go up a step to police officer 1, police officer 2, there's a minimum requirement of how many years you have to serve, 3 years, and you can test for another position up, and you actually have to test for that position. So it's not a matter of me going and getting a reclassification. I think we focused a lot on reclassifications and where there is a promotional process in place. The reclassification, really, I don't see that applying in the police officer ranks. In our civilian side, we've had some, because the job just didn't fit what the civilian was doing in the office environment. And those, I had one go through and got reclassified. It needed to be reclassified. That was probably about 2 or 3 years ago. So am I answering your question? Is that what you're asking?
Yeah, it's not just determined by a civil service merit board or an HR director. It's determined by industry standards. I mean, there are people that can't have my job because they don't have the right degree and credentialing for my job. And my supervisor can't just change that because the institution loses their accreditation and or they get dinged in an accreditation process. It just like in a hospital, you have to have certain people with certain credentials or you don't get your accreditation. So we have things that hinge upon the qualities of the employees. So I mean, we wouldn't be changing requirements for employees and their jobs and pulling the rug out from under them, because we in essence will be pulling the rug out from under everything that we're built upon, and being our city, our bond rating, our insurance rates. I know we're determined upon some of these things. I mean, that doesn't ring true to me. So that's all I was trying to make sense of. I guess, Ms. Hatfield, the rules that are set by the Civil Service Merit Board for class comp, those are the rules that you were referring to. And so the concern is you guys set the rules now. And so the concern is there will be rules moving forward that set these things. And I think, again, I'd like to understand more about the accountability for the class comp system and how those rules are come about.
If I may,
And maybe
do your question.
Sure.
About the standards. As Chief Thomas noted, the only the only time we're bound to a specific requirement, minimum requirement in a job class, is when there is a legal requirement for that. So for example, you cannot be an attorney if you do not have a law degree and you have not passed the bar. You cannot be an engineer if you have not been certified by the State Board of Engineers and Examiners. That does not exist in most of our job classes, including promotional ranks in police and fire. So those promotional requirements in police and fire, while the entry level requirements are going to be bound by accreditation standards, post standards, those promotional ranks are subject to change. There are not state requirements. They can be changed at the will of a chief. Likewise, any job class in the city, that director can request to change those requirements. And I would love it if what you said was accurate, that we know, why would anyone do that? I say that myself. Why would any leader or supervisor want to change the requirements in a way that diminish the job? But I can tell you, in my 15 years as the director, I cannot tell you how many times I have been asked to do just that because someone wanted to prevent a certain employee from being able to promote or apply, because a director wanted to promote an individual that they preferred, but that did not necessarily meet the qualifications. It happens. It happens more than you would like to believe it happens. And we have always been the gatekeeper on that. We don't allow that to happen. But I could give you a long list of examples where those have been requested and we've had to say no, because those criteria don't match what the job should require. So it's particularly concerning for police and fire. We have an amazing police chief. We have an amazing fire chief. We may not always. Right now, those two people would never make an arbitrary decision that would harm their employees. But I can't promise that's always going to be the case. Requirements in police and fire have changed. They have changed since I have been here, and those are usually at the request of the chief. However, when they're requested, I don't have the authority to make that change. The chief doesn't have the authority to make that change. That change can only be made by requesting it before the board. The board has a public input period, and then 5 people have to vote to make that change. I hope that answers the question.
Mr. Shields?
I just wanted to be clear, in the scenario that Dr. Hatfield was describing, if a supervisor or director was engaging in conduct like that, regardless of whether Dr. Hatfield herself is that gatekeeper, the conduct would be wrong, and the charter already prohibits it. So she doesn't have to be the individual that hears that request and rejects it. Whoever hears that request should reject it. And if they didn't, that's where the merit board's powers are at their most robust. That is the great benefit of the merit board, the board, not necessarily the staff who have taken over some of the personnel functions that used to be performed elsewhere. The real backstop is the board, and that's where its charter powers to hear complaints or to take up an investigation on its own and to order that personnel practices that are inconsistent with merit principles cease and desist. So it's not a requirement that the processing of that claim be handled through the civil service staff. What matters most is that employees are sure that they have meaningful checks and balances. And if the civil service executive director or secretary is the person to whom you wish to object, if their decision is the one that you don't have confidence in, you have to really overcome a significant amount of trepidation, I think, to then take your appeal to the board that hired her. But under the personnel department model that we used to have, and under the HR department ordinance, you wouldn't have that fear, because if the HR director had aggrieved you in some way, you're not appealing that decision to the HR director's boss. You're appealing that decision to an independent board. And I just wanted to make sure that that was, said as clearly.
Okay, thank you. And then my last question. So I know in section 2, it was outlined that there will be a director of employee benefits and risk management and a director of human resources. Is that correct?
Vice Mayor, that is already the case. We have a director of employee benefits and risk management. There's just a mistake in the code where that department and that director should have already been listed with the other departments and directors, and they were omitted. But the department exists and the director exists. It's just in that one area where they were left out through some past mistake.
Okay, so at this juncture, in forming a new HR Human Resources Department, we would hire a director of human resources. Is that correct?
That's correct, Vice Mayor.
Okay, and when we talked about acquisition of talent and retention, would this position be posted? Would there be some type of strategy to attract talent, or would we just have this as listed as an in-house position?
Vice Mayor, I would like to post it publicly for sure. I mean, I want to practice what I preach and get the most talented person for these roles, and opening it up to the public would be a big part of that. I'd be happy to accept candidates from internal people, but also, spread it out far and wide and see what kind of response we get.
Okay, excellent. Thank you. Okay. Council members, do we have any additional questions or comments before we go into public input? Okay, I'd just like, before we do that, I'd like to just thank everyone, Mr. Shields, Ms. Hatfield, Mayor, and your administration for all the work that you guys have put into this. As council members that attended the Civil Service Merit Board meeting yesterday, and what we've seen today, this is a huge undertaking. This is a huge task. And something that I appreciate everyone's commitment to being at this workshop so we can learn more about it. Again, if we have additional questions, I think that we have open doors to be able to ask those questions and send by email or phone calls as well. So if there are no further comments or questions, I'll turn it over to Mr. Johnson to proceed with the public input portion of our workshop. Thank you.
Thank you, Vice Mayor. Do our best to go in the order in which we received the persons to sign up. We do have 12 speakers signed up to speak. So we will begin with Arturo Cano. And I will keep the time. 5 minutes. Mr. Kano, are you there? We will come back to Mr. Kano.
Hey, can you hear me?
Oh, yes, we can.
Okay. Okay. Well, can I go now?
Yeah, your time starts.
My name is Arturo Cano, and as much as I am highly opposed to the creation of a new department, I am just one employee. I do have more questions than answers. One thing that really bothers me is the timing. The administration's proposed ordinance was sent to employees at a critical time when employees were not aware of the proposed ordinance. What I mean by that is the administration has sent out an email to all city employees that are on the list served. What is very unjust about that is at the time the email was sent, well over 100 public service employees were self-quarantined without access to the email sent by the administration. Council, I am not sure if you are aware of this or not, but when the administration sends out an email using the listserv, not all employees have a city email. Take for account public service. There are a total of 269 employees. However, more than 200 of them don't have a city email and over 100 of them are at home. That amounts to 75% of public service employees have no idea what human resource ordinance is all about. Every single employee should have an email for the matters of important communications coming directly from the mayor's office. I believe that when the administration selects the city employees using the listserv, they might actually think that every employee is receiving that information. That makes me wonder if all police officers and firefighters have a city email. I also keep hearing about back in the 80s, the personnel department was abolished due to budgetary reasons. With the COVID-19 taking its toll on our city, the city budget now is even more tighter than it has been. Also, I have a few questions. The first question was, why was it put into the ordinance that the employees' representatives unanimously supported the reorganization, in which the city employees league had voted that we did not support that? Second question is, how is spending $250,000 on two positions going to give employees in police, fire, and public service more compensation? Based on March 5th meeting, everyone wanted more compensation. The third question is, civil service has 7 employees that have the title of human resources to their positions. Does the administration plan to laterally transfer them over to the Department of Human Resources? On one last note, does anyone remember that less than 2 years ago, Dr. Hatfield was a finalist for the position of Vice President for Human Resources for the University of Tennessee system? It says here, according to the News Sentinel, the city of Knoxville Civil Service Director has been named one of 2 finalists to the University of Tennessee system Vice President for Human Resources, according to the announcement Tuesday afternoon. Vicki Hatfield, the city's Civil Service Director since 2005, has served in human resources for the city for 20 years. Hatfield and Linda Gaddy, a former Senior Vice President and Chief Financial Officer for Covenant Health System, and also are the finalists. Before Miss Dr. Hatfield was with the city of Knoxville, she was the city's Civil Service Director. Hatfield was Deputy Director from 2001 to 2005. And before that, she worked at the city. She was a human resource consultant for Resource Associates in Knoxville from 1996 to 1999. She earned a bachelor's degree in psychology from Lee University, a master's degree, and a doctorate degree from UT Knoxville. The job that she applied to was to serve as the vice president, among other things, which would consist of statewide responsibility for planning, developing, and implementing system-wide initiatives and strategies that support engagement and customer service excellence. We are very lucky to have Ms. Hatfield with a PhD as our civil service director and a human resource. To us, she is a human resource director, but to have her and for be a finalist of 2 people, just her and somebody else, to be the vice president of human resources for not just UT and Knoxville, but UT system statewide. That's a huge accomplishment.
Mr.
And,
Cano, you have 30 seconds left.
And once again, I believe that let's not try to, if we have a flat tire, let's not try to fix, buy a new car. We need to fix our system. That is, that's what we need to do, is fix what our deficiencies are instead of creating a new department. Because keep in mind, how are we going to explain to our constituents that we're creating 2 positions for $250,000?
Thank you, Mr. Cano. The next will be Philip Reyes. Are you here, Mr. Reyes? Mr. Reyes, if you phoned in, if you would please hit *9 and I can enable you to speak. I'm not seeing anyone. We will come back to Mr. Reyes if he comes in later. Next is Mr. Alex Newbert. Mr. Newbert, I'm enabling you to speak. If you'd please give us your name and address.
Yes, I'm here. Can you hear me?
Yes, I can hear you.
Good deal. Good evening, and thank you for this workshop. My name is Alex Newbert, and I'm a 24-and-a-half-year veteran of city government and a longtime civil service protected employee.
Mr. Newbert, could you give me your address, please?
It's 7424 Castleberry Road,
Thank you.
37721. Can I start over?
Yeah, that's fine.
Excellent. Like I said, thank you for this workshop and for allowing us. It's been a great discussion. It's been nice to listen to. I'm a 24-and-a-half-year veteran of city government and a longtime civil service protected employee. I am currently the manager for the Public Service Department's facility services, responsible for all city buildings, including fire stations, park facilities, and recreation centers. I started my career working in facilities, and through hard work and effort, I've promoted through the ranks. In short, I am a perfect example how important the protections of the civil service are for employees. First, I am a huge supporter of civil service protections. I've personally worked under 5 different administrations, that's 5 different mayors, and having protections from the politics of local government is so important for individual employees. And that is really what civil service is all about, individual employee protection. This is really important for our city and citizens as it keeps trained, professional, and qualified folks on the job and work and serving. It is important for council and all city employees to know that this ordinance does not change civil service protections. Let me repeat that. I've read this proposal, and I've read it, and it does not change protections. I've heard rumors that if this change happens, we will be just like the county. That's 100% false. The change does not affect our protections as they are embedded in the charter. When personnel folded into civil service in the 1980s, the charter did not change. And to create a human resource department at this time does not change the charter. The charter is the most important thing. The current system we have forces a civil service director to wear 2 hats. One hat is all about employee protection. The other hat is serving as an advisor and overseer of discipline, and this system can and does create mistrust of civil service. I have personally felt targeted during my career by the one department that was supposed to be looking out to my individual employee protections. When I was attempting to promote to my first manager position, civil service actually worked adamantly against me and public service leadership. I did end up receiving the promotion and performed the job successfully for 14.5 years. But that experience really brought to light the conflict that exists in our current system. What is really unfortunate is the misinformation that is being communicated by civil service to city employees in an effort to undermine trusting discussions about human resources. I don't feel so strongly about that point right this second because Vicki is participating. She's got good things to say. She's having a discussion with you guys just as you're discussing with her, and I feel good about council is relaying employee concerns. I feel like they've talked to some employees, but at the beginning of this, there was a lot of communicated misinformation. It's not appropriate, and it's a perfect example of the conflict that has been created by current system and civil service having to wear two hats. If you look around the country, it doesn't appear any cities function like Knoxville. We can only find one more city where Civil Service Protections Department are also the human resource function, and that's New Orleans, if anybody wonders what city that is. This whole ordinance is not about employee protection. They are 100% protected, but really about who performs human resource function. I'll close this by saying thank you again, and I urge you to work with the administration to pass an ordinance change that protects the Civil Service Merit Board protections and also creates a functional, supportive human resources department. Thank you.
Mr. Johnson, are you there?
Stephanie, are you there?
I'm here. Can you hear me?
Yeah, if you'd please give us your name and address.
Stephanie Guptail, 6324 Netherland Drive.
Okay, you have 5 minutes. Thank you.
My intent with you today is more to provide a general perspective, and then I'm going to follow up with just a couple of questions. Yesterday, I was on the Zoom call for the Civil Service Merit Board meeting. There was discussion for almost 3 hours, which resulted in the board needing more time to digest and understand this very complex issue that's being discussed again here today before they take an official position. This felt to me like a decision that makes a lot of sense. At the same time, our employees are very concerned about the ordinances to create an HR department, and it isn't difficult from our conversations today to see why. What they are being asked to do is be comfortable with changes that they don't understand, and even very experienced attorneys don't agree upon the ramifications of. The first work group that employees were a part of in March of this year seemed to lose focus from the work group having discussion and instead turned into a Q&A forum for employees, both of which are things that are greatly needed. It is my impression that most people, including some members from the work group, believe there would be more discussion needed since they weren't really able to have much discussion amongst their small group at that time. Thankfully, the ordinance had been postponed for us to have more time for these conversations. Employees are hearing two versions of what the outcomes of this could be, and both of those are from knowledgeable and credible sources. Dr. Hatfield has been our Civil Service Director since 2005, and Board Attorney Mike Winchester has been in his role since 1990. They are both experts in their respective fields. Mayor Concannon is doing great things for our city, and I have so much respect and admiration for all that she has done and continues to tackle in the months since she has taken office. I know that she supports employees and wants to do what's best for them. We also have an outstanding law department that's a wealth of knowledge and experience. All of these things make this even harder because these are all intelligent, thoughtful, hardworking individuals. All of these people work for the city because they believe in what they do. Yet, they don't agree on what the outcome of these ordinances could or will be. I consider myself fairly knowledgeable in regards to our administrative rules, as I work with them just about every day in payroll. And I'm also struggling to understand exactly what these changes would or could mean. I am not someone who is comfortable with just making changes and figuring the rest out later. There are enough bumps in the road when you have already carefully planned in advance. I hope that we will all really use the time that we have to dig deep to bring these two sides, for lack of a better word, closer together and end up with a solution that supports the goals of the administration, the protections of civil service, and most importantly, the interests of our employees. And the two questions that I had, the first one, could the Civil Service Merit Board refuse to modify their rules to comply with the ordinance? And if so, what would happen? And second question, I'm going to poke at section 13 again, like we have over and over. I just have one question that I feel like maybe Dr. Hatfield touched on that hasn't been clarified. And I'm looking at it right now, but section 2, 452, and it says explicitly, the employee shall make the request through channels to the director of the employee's department. If the director cannot resolve the request, the matter shall be referred to the Department of Human Resources for a solution. And I think that is the part where if it's not meant to sound that way, at least to me and to other employees, it does sound like that's leaving that up to the employee's department director rather than the director of human resources. Thank you.
Thank you, Stephanie. The next I have on the list is Carol Mailer. I don't see Carol in my list. If you are phoned in, Carol, you could hit *9. That will raise your hand and I can recognize you. Carol, are you here? I don't see Carol. Kevin Faddis is next. And Mr. Faddis, you can speak now if you'll give us your name and address, please.
Yes, sir. Kevin Faddis, 614 North Central Street, Knoxville, Tennessee, 37919. Let me start out by saying I appreciate following Arturo, Mr. Newbert, Ms. Guptail. I don't have the accolades that they spoke of, but I'm good looking according to my wife. I got a heck of a mustache right now, and I'm a darn good fireman. But no, what I wanted to say is seriously, thank you guys for meeting. Vicki, thank you. Mayor, thank you. And every one of you council members, thank you as well. George, thank you for your time also. We in the fire service recommend that the advancement of an HR department. We feel the complexity of some of these issues need to be charged to individuals who can more closely monitor day-to-day situations. In the always evolving trends involving recruitment, retainment, comp, and class. We strongly feel also that the Civil Service Merit Board should and will continue to protect our civil service rights and protections to all. So basically, that's all I had to say. I enjoyed this, watching this evening, this back and forth, and I think it's moving forward fairly well. So with that, I'll stop talking and let someone else take the floor. Thank you.
Thank you, Kevin. I believe Ms. Mailer has now joined us by telephone, so I will allow her to speak. Carol, you are on. If you'll give us your name and address, please.
Sure thing. My name is Carol Mailer. I live at 7825 Castlecombe Road in Powell. I appreciate the opportunity to share my comments with City Council, the mayor, and guests tonight. I'm a 41-year employee with the City of Knoxville. My position is HR manager in the Civil Service Department. I was employed in the original Personnel Department up until the department was eliminated July 1st, 1986. At that time, I was assigned to the Civil Service Department. Prior to several city departments moving into the city-county building in the early 80s, there was a separate Personnel Department and a Civil Service Department. Most all positions within the City of Knoxville were exempt from civil service status. The Personnel Department has a majority of the day-to-day processes of employee activity, classification, compensation, OSHA, EEOC, etc. The City of Knoxville did not have hiring based on professional merit or an examination process for most employees, but rather the administration and supervisors basically hired employees. There was no formal hiring process or any protections for most employees, no formal selection process. There were very few positions that were privileged to be civil service positions at that time. Most of the civil service positions at that time were clerical related. I recall a large number of employees being hired and another large amount of employees being fired each week for no just cause, no cause whatsoever. If someone simply didn't like someone, they could and did fire them. The good old boy system allowed supervisors to hire family, friends, and friends of family. Some employees were hired based on their political status, who they voted for, and who they knew. When the charter change went through in 1980 and brought most of City of Knoxville positions under civil service protections, the roles of the two departments were basically changing over the next few years. I was young, but I always recall dissension among the two departments. It was very tense to work in this environment, and to say the two departments did not get along was an understatement. When both departments moved to the city county building in the early 80s, we actually shared the same hallway where civil service is today. Each department had their defined space. You basically didn't cross over. We each had our own employee files and our own office set up. They did not function together. There was constantly disagreements amongst the two departments about their roles. A lot of basic functions were duplicated. As a large portion of job functions migrated into the Civil Service Department upon the 1980 charter change, it made both practical and financial sense to eliminate the Department of Personnel. The 4 staff members left in personnel. 2 positions went to civil service and 2 positions went to benefits, which was under the law department at that time. The civil service system was put into place in the 80s, is exactly what the employees needed: a merit-based hiring system, protections from any wrongdoings, the rights to appeal disciplinary actions, opportunities to compete and further themselves through the defined promotional process. All the privileges they are familiar to now, that we are familiar to now. In closing, a significant point that I think is being missed in the back and forth conversations is the combined functionality for 35 years has given employees protections they did not have before and will not have if the ordinance passes as it's written. Employees are used to these protections and rely on them. The ordinance is not in the best interest for anybody, especially the employees. Thank you for your time.
Thank you, Carol.
You're welcome.
Next, we have Casey Kraus. And Casey is here.
Yep,
Casey,
I'm here. Can you hear me?
Yeah, I can hear you, Casey. If you'd please give me your name and address.
Yeah, Casey Kraus, Shannon Lane, 4909 Shannon Lane. I just want to thank council and everybody for the time to discuss this important issue for both me as an employee and the customers we serve. For those of you I haven't met yet, and I've met many of you on council, I'm the urban forester for the city of Knoxville. I'm a civil service protected employee and a member of the general government and a proud Fountain City resident and taxpayer. I've heard a lot about this ordinance the past couple of weeks. To be honest, I have not really understood why there is so much controversy over the creation of an HR department. Ironically, a few weeks ago, during the early onslaught of the COVID-19 pandemic, I received a phone call from my sister in Fort Wayne, Indiana, checking to see how things were going here in Knoxville. You see, my sister is a human resource director for Allen County, the second most populous county in Indiana, where about 5,000 employees are. During our conversation, she was asking me what our human resource department was doing in preparation for the COVID-19 pandemic. She was quite shocked to learn that we had no human resource department at the city of Knoxville. I think this was when I really started to think about the proposed ordinance and what that really means. Now, I'm a tree guy and I'm intrigued by research. So when I began to do research on government HR departments, I was quite hard pressed to find many local governments with without an HR department where the same person of with the same person oversight of human resources and the executive secretary charged with the merit grievance system. To me, our current system is set up where one entity is the judge, jury, and executioner, or for this conversation, hires, fires, and gets to determine who's the liar. I have talked to several of my colleagues and employees, and many of them are in support of the HR department. For one reason or another, and also like me, are very much in support of maintaining protections under the Civil Service Department. By no way should an HR department eliminate the need for those employees within the Civil Service Department or those tasks those employees already do for the city, whether under the Civil Service Director or HR Director. There may be some need to look into the language with the proposed ordinance to address some of the concerns that we heard tonight. But all said, I believe an HR department would bring more accountability and checks and balances to a system but more importantly, provide the necessary training and support for employees, help them excel at their job, and generate career development. We also need an HR department to assist in finding the best candidates for our jobs and promote the city of Knoxville as a place to work. We need an HR department to understand the needs of our managers and work with us in making sure those employees are able to do their job safely and compensate fairly. Compensation needs to consider the current economic situations and not only compare our employees to other municipal workers, but also the private sector with consideration of our own benefits. Again, I am in favor of our civil service protection for city employees, but also believe by designating an HR department, we can make great improvements for our employees and provide better transparency for us as well. Thank you.
Thank you, Mr. Kraus. Next, we have Mr. Ben Buckner. Mr. Buckner.
Hello.
Yes, if you'll please give us your name and address. You have 5 minutes.
Ben Buckner, 3325 Gumstand Lane, Powell, Tennessee, 37849. Good evening, council members. I know these are unusual times we are in right now, but I would like to thank you and everyone else involved for allowing myself and others to speak tonight. On behalf of the City Employees Association, I would like to read a statement. Talks of the HR civil service split began last year and were put on hold till recently. We have been given information from both sides of the argument in regards to the civil service split. Before the first work group was scheduled, the CEA in February called for a special meeting to go over the information and discuss the topic. Based on the information at the time, the members in attendance unanimously voted to recommend the administration to explore other options other than creating an HR department. During the first and only work group meeting thus far, we presented our recommendation, listened to the administration's response, as well as civil service. The meeting went on for about an hour and a half, and the conclusion was that we would have more work groups set up in order to deliberate the matter further. Since then, there have been a couple of new changes and not discussed in the previous meetings. The current pandemic has made this extremely difficult to have work groups and also to have our own meetings with city employees to inform them of the changes. The association at this time would hope that all parties can delay any decisions on the matter till such time we can have face-to-face group meetings and continue to have work groups so we can give accurate information to our members. The association also feels at this time, when the city's budget is being stressed, that adding an additional department does not make sense. With funds being restricted, it is better to wait till this pandemic is over and proceed from there. Based on the current information given to the City Employees Association, at this point, the association is not in favor of adding an HR department. Thank you, guys.
Thank you, Mr. Buckner. Next, we have Tina Newman. Ms. Newman, I do not see your name in the list. If you'd please raise your hand. If you're phoning in, please select *9. Okay, I see you. Ms. Newman, if you'd please unmute yourself. Ms. Newman, are you there?
Yes, I'm here.
Okay, if you'd please start by giving me your name and address, and you have up to 5 minutes.
Yes, my name is Tina Newman, and I have a P.O. box, so it's 501 West Main Street, number 521, Knoxville, Tennessee, 37902.
You're free to go, ma'am. This is.
Oh, okay. I'm really new to the city, so I just wanted to be on this call and to let the city council and the new mayor know that I am interested in the changes. I'm interested in the old and the new. I think that I'm really nervous. So I just wanted to just touch on what Amelia Parker had said about allowing more time for just regular old Joe employees like me to understand the changes that are happening. I know personally, and the families are experiencing a lot of hardship right now. And to be able to deal with this whole new situation in a pandemic is very, you can't really focus on it. So I just wanted to let everybody know that I'm here and I'm listening. And I did sign up for the City Employees Association, which it was a group that I wasn't aware of that existed. So I'm definitely excited for the growth and learning different things in this process. And I appreciate all the work that all the city council members have done to make this meeting happen. I know you guys are probably wore out about now, but thank you. And I just want to let other employees know that we're all in this together and we can learn together. So thank you.
Thank you, Ms. Newman. Next, Mr. Lyon, it was said earlier, could not attend, Mr. Keith Lyon, but he did ask that I read a statement. So I will begin with that. We support a split of duties between the Human Resources and Civil Service Board. When the duties were combined, it was a reasonable course of action during that time. Over the last 30 years, the process of hiring itself has changed. It was standard across the nation to take a year to get a job in law enforcement. Within the past decade itself, the recruitment pool has dropped 75%. The exit numbers are increasing each year. 30 years ago, 2,000 to 3,000 applicants were standard for an academy class. Now it's 200 to 300. Other agencies have reduced their hiring time to as little as 90 days in some cases. They have evolved to meet the job market. Our current hiring process has not. Applicants aren't just trying to get on at just one agency. They apply in as many as 3 to 5 at a time. If they can be hired sooner than a year, we lose them. Other agencies have stepped up their recruiting process to allow potential applicants to apply and take an entrance test on the spot at job fairs, putting them a step ahead of us. Other agencies allow active duty military service members to waive the physical test as long as they show a current test for the year of application. The recruiting process needs to have more personal contact with potential employees. The police department needs to have that kind of access to applicants, which it does not. The city needs a more modernized way of attracting potential employees. The city needs to allow civil service to protect employees' interests as what they were formed to do. In the area of complaints, most employees feel like the current setup, while civil service acts both to protect employees and serve the personnel interests of the city, it only protects the interests of the city. In the most serious area of sexual harassment complaints, an employee is called to civil service and told that cannot wait for advice from a lawyer, even though such a drastic accusation has the potential to not only cost a person their job, but also their life. Due process should be protected in such accusations. After all, the innocent is often accused. An institution that is supposed to protect the employee's rights and look after the city's personnel interest cannot effectively look into accusations of that magnitude with objectivity. Sexual harassment is a highly sensitive accusation, which an organization is naturally going to protect itself first, which can cause an innocent person harm. When this work started, there were a couple of areas that were of concern, such as classification and compensation. Once these areas are totally squared up with city employees, human resources, and civil service departments, would be a good fit for the city of Knoxville. And again, that was a statement by Keith Lyon, current president of the FOP for Knoxville. The next we have is Deborah Jeffries. Ms. Jeffries, you can now speak. If you would please give us your name and address. You have up to 5 minutes.
Thank you. Can you hear me?
Yes, Ms. Jeffries, we can hear you.
Okay. My name is Deborah Jeffries. Live at 109 Foster Road in Anderson County. I just want to thank the council members and the mayor and vice mayor for hearing me out today. I've learned a lot today about how things run under civil service, but I'm all about having a human resource department. I think it will free up civil service to focus more on the employees and issues that arise. I believe human resource will be able to focus the needs will be able to focus on the needs of the departments with recruiting new employees and background checks. I would rather have civil service fighting for my rights and be focused on my problems than have them thinking about other things that they need to do for the day if I ever needed them. Human resources will take some of the burden off of civil service. Human resources will be able to handle small issues for the employees under certain guidelines, and then more serious issues and offenses the civil service can take responsibility for. But I believe the Human Resource Department should have all new employees in it. That way it'll start out as a fresh department. I'm hoping that both departments can work together. Just because they didn't get along back then doesn't mean they won't today. As a military vet, we have a saying, it's adapt and overcome. I'm pretty sure we can all work together. Thank you.
Thank you, Ms. Jeffries. I've heard contact from Mr. Reyes. He cannot be with us, but he had prepared a statement in the case that he would not be able to join us. So I will read that now. My name is Philip Reyes, 3400 Fountain Park Boulevard, Knoxville, Tennessee, 37917. I am a city employee and also a board member of the City Employees Association, which represent general government employees. I want to read a statement from the association. The City Employees Association called a special meeting and voted without dissent that our position was for the addition of 2 positions rather than the creation of a new department. First, an attorney in the law department to assist the administration and departments with discipline, interviewing, selection, and employee management disputes, where civil service is representing the employee. Second, a human resource analyst in civil service to help with career building, job retention, talent acquisition, and marketing. This was presented at the Mayor's Work Group on March 5, 2020. I want to read a few brief statements on behalf of the members. We are currently in a state of emergency. This is not the time to be making these legislative changes. During this crisis, employees are not able to attend the council meetings and have their voices heard. Employees are focused on their work and keeping their families healthy. This is placing unnecessary stress on those who are already overwhelmed. There has been one work group under this administration, and employee questions and concerns were not satisfied. There needs to be much more conversation and clarification. Although the salary for 2 positions have already been budgeted, there will be additional funding needed to establish a more permanent department. Many departments citywide are experiencing funding issues and are being told to cut back spending. Why should this not be treated as the same? I would like to add that the employees of the City of Knoxville are the ones who will be operating under these new rules beyond this administration. I believe the goals of Mayor Kincannon are genuine and in good faith, but I believe the proposed ordinance should be tabled indefinitely until social distancing guidelines are removed, budgetary issues are resolved, and we as a city need a period free of COVID-19. Thank you, Philip Reyes. That was a statement he had given me in advance of the meeting. Next, we have Robbie Coram. Mr. Coram, if you're there, if you'll please give me your name and address, and you have up to 5 minutes to speak.
Robert Coram, 108 Oakwood Drive, Maynardville, Tennessee. I began my career 16 years ago with the city of Knoxville. I was privileged to work with Mayor O'Hara, was the president of the City Employees Association last year on this topic and on this work group. I can say that there are a few differences between the discussion we had then and this discussion that's going on now, mainly with compensation and classification. But it was determined then amongst the members of the work group, and it continues to be, that there is definitely a place within the city of Knoxville for a human resources department based upon the different tasks that are there. There is a clear conflict as civil service reaches out to represent the employees. However, many department heads also reach out to civil service for guidance on the different issues and how they should proceed with disciplinary actions. So there is a conflict of interest there, which should definitely have an HR division among it. I am a little concerned about the compensation package and the classification package going to an HR department instead of a civil service department. I'm concerned, and I realize that civil service merit board does protect all employees. It's laid out in the charter in section 1003, paragraph F, chapter 12. And it basically says that if anything comes that is unmerited, that civil service merit board would have the ability to cease and desist all those actions. So I just ask council that as you read through the charter or read through the ordinance that's coming up, I ask you to pay close attention and make sure that the protections are held in flux or held to truth, so that we would be able to maintain the careers that we've had and the experience that we've had. I appreciate the dialogue, and I appreciate the communication that's went forth. I honestly think everyone has the best interests of the employees at heart. It's just we want to make sure that we get this right so that we're not coming back in the next few years and trying to reinvent the wheel. So I want to thank you all for your time. I want to thank you for your efforts and your energies. I want to thank you for taking time to listen to our phone calls and our emails. I also supervise several employees within the public service department, and their concerns have been addressed tonight, and I'll be relaying that to my crews in the morning, that the protections are there. We just want to make sure that they're upheld, as is the intention of everyone. So thank you very much for allowing me to speak, and have a good night.
Thank you, Mr. Coram. Our next speaker is Mr. Larry McAfee. I do not see him in the pool. Mr. McAfee, if you were here, would you please raise your hand? If you phoned in, would you please hit *9? I see you there. Mr. McAfee, can you hear us?
Yes, sir. Can you hear me?
Yes, sir, we can. Would you please give me your name and address? And you have up to 5 minutes to speak.
My name is Larry McAfee Jr. I live at 3333 Clearview Street. That's Knoxville, Tennessee. I've been an employee with the city of Knoxville for almost 8 years come July. I work in the fire department. I'm the vice president of the Firefighter Association. I support having a department within the city that focuses on recruiting the best employees in the country and retaining those employees. A department that will concentrate on competitive compensation and benefits, training and developing the employees, and working to ensure that there's a great employee-employer relationship, and also focus on labor laws and labor law compliance. These descriptions I just gave you are that of a human resource department. These are not the role of civil service. Civil service is there to protect the employees. I have an example of where civil service had a shortcoming. When employees are promoted, another example was given from senior to master firefighter, there's a pay increase. Well, there's an instance where certain firefighters got those promotions and they was making more than a person who'd been in that position longer. The solution the civil service department had was to simply increase the older employee by a couple of $100. Well, the Firefighters Association and the department head has come up with a plan to fix those inequities, but they've been shot down. I feel like the HR department would oppose that new solution that the fire department has given. And also, Ms. Hatfield seems to have a lot of accolades, and I feel like one solution would be for her to simply apply for the HR director position. Thank you.
Thank you, Mr. McAfee. Our last speaker tonight is Mr. Mark Taylor. Mr. Taylor?
Yes, can you hear me, sir?
I can, sir. Would you please give me your name and address? And you have up to 5 minutes to speak.
Mark Taylor, 2706 Alice Bell Road, Knoxville, Tennessee, 37917. So I want to speak in favor of the ordinance. And I think probably, you know, I know there's a lot of emotion in this and there's a lot of fear in this and you know, type of stuff. And I hear that from a bunch of different people. But at the end of the day, you know, the primary function of any government, any municipal government, state government, federal government, is to provide for the public safety of its citizens, its residents, the folks within its boundaries and borders. And we have struggled to maintain police officers and to maintain the minimum staffing, or the allotted staffing for the police department. And that staffing is a reduced staffing from the mid 2000s already. So that puts a lot of extra responsibilities and changing times back onto the average police officer that's answering calls. And the job has gotten exceptionally more complicated over the years, less resources, less manpower to do that. And we're asking a lot more of very young people, and then we're going to expect them to stay in this job and capture that experience and provide that so that the citizens get a good service from us. So the environment has changed. I pointed this out several years ago, and sadly at the time it wasn't really kind of viewed legitimately. The most important thing that a decision maker needs is relevant, timely information and data so that they can make the decisions that they need to make so they can provide the services, the product to the citizens, to their consumers. And it's not a personal thing or anything like that. It's just that it isn't working currently. It's not working well. Our processes have been very slow to change, and in some cases haven't changed. And that's not reflective of what we're going to need to be able to compete going forward. And I feel like a professional HR department that's just focused on HR and doesn't have to be conflicted or having to wear two hats or perform this duty and that. And that's not fair to civil service or HR or whoever, whatever organization you come up with to fix the issue. That creates a conflict. So my suggestion is remove that conflict, hire folks that focus specifically on getting us the information, the decision makers, you, this body, the mayor, the chief, the information they need to overcome this obstacle, and let's reverse this trend. Because it's having really bad consequences for our employee population. I respect all of the conversation tonight. I I'm very happy to hear the mayor be so willing to address some of those issues that, quite honestly, and some of those, the ones that you went over, and Councilman Roberto and Councilwoman Ryder, were some of the issues that our employees that I've heard had some of the biggest issues with. And that gives me a lot of faith in the process as it's going. I think we've had good dialogue on that. Thank you for your time.
Thank you, Mr. Taylor. Council, we do have someone who's raised their hand. It's a telephone number. I don't recognize it. We have completed the list that we had for public speakers. So I'm going to look to council if they want to hear from this person who's raised their hand. Vice Mayor, then we're finished with,
I would move to let them speak if they're available.
Okay.
I'll second that. And then if for some reason it's a violation of the rules, then.
Sure.
Okay.
Okay.
Mr. Johnson, if you will, go ahead and let this caller go ahead and speak, but we will not allow any additional callers because we do need folks to sign up prior to the
Yes,
calls to
ma'am.
speak going forward. Thank you.
Caller, if you'll please identify yourself. Can you hear us, sir? Phone number ending in 867. Okay, they don't answer. They raised their hand while when Mr. Taylor originally spoke, so.
Okay. Thank you, Mr. Johnson. That may have been by accident. Council, that concludes our workshop. Again, I want to thank Councilmember Testament.
I'm sorry. I needed to bring one thing up that I wanted to see if Mr. Shields could please clarify. In the public forum, Ms. Mailer mentioned this, as did, I believe, Dr. Hatfield throughout the evening, mentioning about there was a charter change in 1980. Based on what I heard yesterday at the Civil Service Merit Board meeting, my understanding is the charter has not been changed since 1969. So I'm trying to get some clarification around that because I've heard both, and I think it'd be beneficial.
Sure. Thank you for the question. The charter as a whole has not changed from top to bottom in quite some time, but parts of it have changed. And one of the parts that changed in 1980 dealt with the civil service system and the personnel system. So it wasn't a full scale change. It was more of a piecemeal change.
Okay, I just heard something different yesterday, so I just wanted to make sure there was some clarification around that. Thank you.
Okay. Any other questions or comments? Okay. Seeing none, again, want to thank everyone for your time today. Thanks for all the presenters, to the mayor. Yes, Mayor.
Vice Mayor, I don't know if you had wanted me to give like a 2-minute update on COVID-19 or not. I'm happy to do it or happy not to, whatever the council wants.
Yeah, if you don't mind, Mayor, if you would, please. Thank you for that reminder. I forgot that quickly because it was requested by Councilmember Parker. Thank you.
Okay, I know it's almost 9 o'clock. I'm still at the office and haven't eaten dinner, and I know you all are tired too, so I'll keep this short and we can talk more. Or I mean, we can talk as long as you want, but as you guys know, I'm sure you're following this. Today, COVID-19, we had a total of 186 positive cases. That's up 14. We've had a pretty flat number of new cases in recent days, like up maybe just 1 or 2. But today we had up 14. That may reflect that the health department's been able to test more people. We're just going to continue to monitor, monitor the cases, and there are 38 active cases, 144 have recovered. Fortunately, we have not had any new deaths, so 4 deaths. So that's as of today. I guess a couple things I wanted to just mention is that I am, working with all kinds of groups to hear their concerns, and would love to to the extent possible that you all have time, to include you guys. Yesterday, we had a meeting with small business members, of local small business members, where I was asking them, you know, what their experiences have been and what their obstacles are. And Patricia Robledo and Stephanie Welch are gonna, you know, we're gonna follow up on that and see, you know, what kind of, you know, for people, example, having challenges with getting the payroll protection plan. You know, it's not as flexible as they want. It's not, you know, this, and now today we hear the money's all out, but some of the employers have said they got a lot of money, but there's so many strings attached they can't use it, or that their employees would earn more on unemployment. You know, it's complicated, but anyhow, I thought it was a good, you know, a good initial meeting, and it had people from the restaurant business, retail, some people advising those people, a hotel person, someone who runs a yoga studio. I can send you the list. Well, I'll just tell you, Ashley Capps, you know, from AC Entertainment. It had Nelia Veronica Kirtley, who runs several restaurants, including Soccer Taco. Jim Clanaris, who owns some event spaces and restaurants. Kim Lomanaco, who owns Going Body Yoga Studio and also has a job at UT Medical Center. Joey Natour, who owns Pete's Coffee Shop. Alpesh Patel, who owns several hotels, including the new Embassy Suites downtown. HQ, his full name is Hasib Qureshi, who's an attorney who's been offering advice to business owners and how to navigate all the state and federal resources. Lisa Sorensen, who owns Bliss and Bliss Home. Ryan Steffi, who manages Sono Taco. And also Nikisha Thompson, a realtor. And that was interesting because they're considered an essential business and they've been open, but of course, people's incomes have changed, the ability to show houses have changed. So even businesses that are quote unquote essential have had a huge impact on their ability to conduct their business. And last, some people who couldn't participate, but the last person who participated was Adrian Webster, who's a tax and accounting person for a lot of small businesses. And the reason I thought it was especially important to talk to small businesses is because they're the ones that are least likely to have a big reserve to like tide them over until, you know, we can reopen the economy. And so that's the first of, you know, other meetings to come. Let's see, I'm going to be having a Zoom conference with the Community Voices Coalition on Friday, because you know you're familiar with that. That's a group that's very focused on equity concerns, and they want to make sure that the city and county and other people are making sure that testing and healthcare access and business, you know, all the things that we're doing in response to COVID-19 are reaching all sectors of our community. You know, including people who may not be able to do Zoom meetings and may not be able to access information in ways that are, you know, through the internet or whatever. So I'm looking forward to that conversation. You may have seen that today I announced, been working on a task force with my mayoral colleagues in Memphis, Nashville, Chattanooga, and also here locally with Mayor Jacobs. And we appointed a task force of you know, there are 4 people from each metro area. And it's a task force that's going to be working with the governor and his team. The governor basically now has 2 teams. One's like the medical side, making sure that the hospitals have the capacity they need in case there is a big surge. That's called the Unified Command. And then the other team is called Economic Recovery Group. And they just basically were put together this week. And they are focused on the economic aspects. And so our task force has business people locally. The people that Mayor Jacobs and I appointed include Kathy Brown, who's a PhD and master's in public health professor at UT, and also Dave Miller, who's the president of First Horizon, formerly First Tennessee Bank. Mike Odom, Knoxville Chamber president, And we wanted a small business representative on there. So Ryan Steffi, who's at So No Taco, he's going to be on this too. And you may have gotten the press release. If not, I can share it with you. There's also a lot of outstanding people from Memphis National and Chattanooga, infectious disease specialists, hospital people, but also small and large business owners. And so basically the idea is that they will come up with some recommendations for what are the health criteria that we will look for. My understanding is that, we want to have 2 weeks of flat or declining numbers of new cases before we, remove restrictions. But I want to wait and hear from them. That's just what I've gotten from, reading a lot about it. And then you want to make sure to have widespread testing. And I know that they're ramping that up quite a bit in Knox County, but also across the state. So they're going to help recommend, what the criteria are, and then also do some guidelines, sort of similar to what, Mayor Jacobs released a 3-page set of recommendations that he shared with the governor. The governor's asked mayors, what are your ideas for how to reopen the economy? And so my first idea is make sure we don't do it prematurely, but also understanding that we're not going to have a vaccine for COVID-19 for a long time, maybe a year or longer. And so we can't, the economy, we have to learn how to operate in new, safe ways and have new norms where, wearing face coverings is considered the norm, especially if you're in a close proximity, and where, retail and restaurants and other things, just, whatever it is. And so this entity is going to recommend, whether it's a fitness center or, Bush Beans manufacturing or an office setting or a small clothing store or a restaurant, how can they operate? And when can we remove restrictions in a safe way where we don't, where we can get the economy going back, but also don't unleash, in a way that the COVID-19 is going to spread beyond our medical community's ability to handle it. So that's what we've been focused on. And also we're continuing to work closely with the United Way and CAC and Second Harvest and all the social service groups that have been convened. As you know, the guest house is opened to serve our homeless neighbors who have been tested and maybe even found to be positive. It has a room for 18 currently. It did have a few people in there who were tested and awaiting their test results. Apparently their test came back negative and they've left the guest house. It doesn't have any nobody's staying there right now. So that's good. I hope that we, continue to have positive results like that. Let's see. Also, I'm, preparing a budget. I was going to do a State of the City address next Friday, and I'm still going to, but it's not going to be a public event. But, that's going to include the regular sort of budget components, but also a proposal for how the city can spend and, spend money on social services and protecting our vulnerable residents in the COVID-19 response as well. So that's going to be, we're working on that, and it should be, a proposal that comes to council and the rest of the city and community a week from tomorrow. So that's my short COVID-19 update. I'm happy to take questions. We can also talk more about it, Tuesday.
Okay. Thank you, Mayor. Council, any questions?
Just, will we know more about the plans for the budget address at Tuesday night's council meeting?
Yes.
Okay.
Basically, the plan is we're not going to be able to do things in person. So, and in thinking about how it's been, I've been to a bunch of them in the past for previous mayors, and it's usually, it's a great presentation, but it's not super interactive. So we're trying to figure it out, and we want to make it be as informative as possible, but also, in this new constraints. But I'll share. It's a work in progress, and obviously there'll be the presentation and a little pomp and circumstance involved in that. in a virtual manner, but then we'll have many, city council budget hearings and city council meetings to consider the budget and all that as well. That'll be probably in a Zoom setting, but we're not going to do Zoom for the budget, state of the city address. That'll be some other way. I'll let you know Tuesday.
Okay. All right. Thank you, Mayor. Okay, council, if there are no other questions, comments, or concerns, we're going to go ahead and adjourn the meeting. Again, thank you, everyone. Mayor, get some rest. Thank you for staying out late with us. Everyone have a good night.
Thank you.
All right.
Bye-bye.